And Mr. Yobin, yes, my lord. Mr. Yobin already informed my lord that he won't be here.
Okay. After vacation.
Much obliged.
Item number 1.
May it please, Lordship. Lordship, this continuation of delay, Lordship. There's a delay of 101 days, Lordship, in preferring the appeal.
Any private respondents?
Lordship. Respondent number 7, Lordship, is there.
You accepting notice? Yes.
Lordship, I have no instruction.
Then why is standing? Who's going to appear to state?
KP Bhattacharya.
Fine.
I'm praying for notice.
Issue notice in the missed case, on the condemnation application. List after vacation steps we taken within 3 days.
Deeply obliged.
Item number 2.
No.
1 second.
Well, kindly have the order sheet dated 17th.
1 second. 1 second. Yes, they have not filed an affidavit as yet.
Yes, my lord. They have not.
Where is who's for respondent number 226? Mr. S. Chetia. Who's Mr. S. Chetia? No one's here today. You're for number 1. You're not filing anything.
No.
Who's Mr. Chetia?
He's from Guwahati, Your Lordship.
He's not available online also. What to do? Mr. Bansal. What to do,
Yes,
Mr.
ma'am.
Bansal? Yes.
My lord, some date that is fixed. And,
Yes.
That the,
Yes, none appears. Mr. Bansal. Mr. A. Bansal is present on behalf of the petitioner. None appears. And MSR Gurung, Vice Dr. N. Bozika for respondent number 1. None appears response 226. By the last order dated 12/11/2024, Mr. S. Chit, or 21/11/2024, Mr. S. Chetia had sought 3 weeks' time to file affidavit. However, it is noted that the affidavit is not yet on board. So, next, in the interest of justice, lists the matter after vacations on so and so. Is expecting that the affidavit should have been filed. Yes.
my lord, kindly fix any specific date, my lord. if
What date do you want? In February?
My lord, may have on 10 if possible.
10th. Yes. 10th is a
Stay may be continue. Stay order may be continue, my lord.
yes, sir. Stay order shall continue. Yes, interim order very shall continue next day. Yes.
Obliged, deeply obliged, my lord.
Item number 3.
May it please, Lords. Well, these matters were pending before the Honorable Apex Court, my lords. The Apex Court has now finally disposed of these matters in favour of the petitioners appellants before your lordships, my lords. Court Master.
Such a long judgment.
My lord.
So that means these matters can be closed in the peace.
Lordships.
Your Lordship, I pray if in that case, Your Lordship, I pray if this matter may be taken up at the end of the board, Your Lordship.
After vacations.
After vacation, Your Lordship. Because we need to go
There
through
is
the
some,
judgments,
there
Your
is,
Lordship.
my lords, this issue has been settled. I think my friend Mr. Mosika is also aware. Para 11.12.6 at page 75, if my lords kindly have a look at it.
This is before para
11.12.6, my lords.
11.12.
Page 75, internal page 75, my lords, the penultimate page.
Why did you get something? You answered this. 11.12.6.
My lords. May I read, my lords?
Yes.
Having held that the tower and prefabricated buildings are goods and not immovable property, and since these goods are used for providing mobile telecommunication services, the inescapable conclusion is that they would qualify as inputs under Rule 2K for the purpose of credit benefits under the Senvet rules.
Dr. Mosika, you have seen this order?
Well, it was served me yesterday. But if the matter comes out of vacation, I'll take instructions from the department whether this covers the entire matter. But there are 2 appeals, one filed by them and one filed by us.
Where is this disposed of?
Well, this was disposed of. This is dated, my lords, 20th November 2024. If I may draw your lordships to the order sheet of this honorable court. If I may draw your lordships to the order dated 28/2/2022.
28 to
22.
2022. Where's the order sheet? Yes.
Here, my lords have it. May I just read it, my lords? It is submitted on behalf of the petitioner that the order impugned dated 30th October 2018 passed by the Customs Excise and Service Tax Appellate Tribunal is founded on a judgment rendered by the Bombay High Court, and the validity of such judgment on the issues decided thereunder have been carried to the Supreme Court, and the matter is pending for consideration. It is submitted that the hearing before the Supreme Court is so and so. Let this petition appear 4 weeks. So, my lords, thereafter also the continuous orders. Next order 28/3/2022. Since the
It
matter.
doesn't matter, Mr. Paul. Let it come to vacation. In all fairness,
Immediately out of it.
Mr. K. Paul, advocate so and so, have placed a copy of the judgment rendered in civil appeal number so and so, which submits will squarely cover the incident matter stop. Mr. Dr. Musica, the TSI, however, prays and be allowed some time to obtain instructions before the matter is finally closed. Yes, in consideration thereof, list this matter immediately on reopening. A copy of the judgment is kept in the records.
Item number
It
5.
should cover then.
Well, the only issue here is whether these mobile towers, the erection of that, Malats, would be eligible for input tax credit. So initially, Malats, there were two divergent views by the Delhi High Court and the Bombay High Court. Matter was carried to the Supreme Court, Malats, and the Supreme Court has now answered the reference.
What's your appeal? Okay.
Their appeal is against Malats on the same issue because the appellate order, Malats, had disallowed part of the Malats appeal and disallowed part of the appeal which was time barred. So to that limited extent is the issue. But the core substance of the issue is, Malats, that whether that would be eligible for input tax credit.
Item
So
number
once
5.
this is answered, Malats, everything goes.
Item 5, I appear to the petitioner.
Yes, Mr. Musa.
The pleadings are complete. I'm ready for hearing. It's a very short matter wherein the A17 adjudication order is in violation of the A16 master circular issued by the Ministry of Finance.
Yes, Dr. Musica.
And the short.
But I was praying the matter come after vacation.
Any interim orders operating here?
Yes. There is no coercive actions may be there.
No, we'll take it after the vacation since the last day. Yes, the matters
Specific posting date may be.
yes, the matters come for hearing on the period of Dr. Musica. The personal difficulty lists this matter, which the notifications on which date?
Any date, madam.
Immediately.
Yes,
Immediately, maybe third week of January. Third week.
no, we're still closed 3rd week January. We'll make it first week of February. Yes.
First week. But my lord, may make one request.
Yes.
Can it be posted for disposal, my lord?
See, that's up to the court whether we can dispose that day or not. Last date you're not present. You're going to dispose it on the last day.
I admit, my lord. I admit.
Yes.
Yes, my mistake. Obliged. Let the interim order continue.
Any mention?
May it please your lordships. My lord, I seek your lordship's permission to move in a writ petition unlisted, my
What's the
lord. In
matter
fact, this was filed, in fact, my lord, Friday. This is, my lord, from EPF. From EPF.
From EPR?
Employees Provident Fund Assessment. I have served the copy on the other side and informed her also.
Your Honor, let the matter come up in the end of the board.
Unlisted only.
End of the board?
Yes, Your Lordship.
Lordship, similar prayer. What has happened here is, Lordship, we wanted to file a misapplication for extension of time for compliance of the judgment on order passed by this Honorable Court.
Yes, yes. But if you mention the matter, that will be urgent, huh?
Your
Don't
Lordship.
mention for sake of mentioning.
Your Lordship, I'm mentioning an unlisted matter. There's some urgency, Your Lordship.
What is the matter about?
Your Lordship, in this matter,
Eviction, demolition?
no, Your Lordship, there's a construction going on with where the pata is illegally issued by the CM of Millim, and there's a pending matter before the trial court. Ex parte order was passed against the CM of Millim, and in the meantime, they issued pata to the private respondents, and right now construction is going on.
Where is this?
Lumpering, Your Lordship, Upper Lumpering. Your Lordship, we have already filed the matter. Highly obliged.
My lord, I beg Lordship indulgence regarding yesterday's matter, my lord. Lordship, Maurapat School, my lord. In the last occasion, Lordship has directed to submit the written submission.
Oh, you didn't submit?
I have submitted, my lord, due to miscommunication, it was submitted to court master. I informed my senior colleague, Mr. Abraham, but he did not make a submission, so it was difficult for the court master
When
to put on
Mr.
the
Abraham?
record.
He didn't appear yesterday also?
My lord, it appears he appeared, my lord. So it was item number
He
43 and
didn't appear, he
44.
disappeared at that time.
So my lord, the reason for this mentioning is I would like to submit the record, Lordship. May kindly have it on record, my lord, on behalf of the state respondents.
I don't want to keep a CAV yesterday. That's the only. I don't want to keep any CAVs. The only CV I've kept was because my computer crashed.
Just a small miscommunication, my lord. I have actually submitted to court master.
Okay. Yes. Yes.
Your Lordship, I beg to mention item number 15.
Louder.
Item number 15, Your Lordship.
This is mouse.
Mausaumi Ingi Village.
So we have no objection, Your Lordship.
Yes. 15. Yes.
Your Lordship, I pray that the matter may come up after vacations.
Yes.
Your,
Number 3.
Recording.
Your Lordship, similar prayers for item number 17. 17.
Who's the petitioner?
I'm for the petitioner, Your Lordship.
In 17?
Yes, Your Lordship.
Even in the other one also 15?
Yes, Your
No
Lordship.
objection?
No objection.
Okay, yes.
Obliged.
Malcolm Star.
Yes, Your Lordship.
Yes, of me, number 4. Yes.
Right, Your Lordship.
Supplementary list, item number 1.
Yes.
Lordship, I've approached this honorable court because all the district council courts have passed orders in the instant suit. So, Lordship, this
What do you agree with?
the
Order, this says
order dated
court is inclined to allow petition
3-5
continuing 2 years, 10 months.
Yes,
in filing
Your Lord.
sufficient petition. 2 years, 10 months delay in filing sufficient application allowed.
allowed, Your Lordship. And item number 2 is the order passed regarding the substitution petition, Your Lordship. They are connected
Will
matters.
issue notices. Yes. As civil courts are going to close now.
Yes.
So, what Mr. E. Thabal and counsel for the petitioner issue notice the solo spondal returnable in 4 weeks. Steps will be taken by registered AD within 3 days. This accordingly on so and so. What item 1 and 2?
Obliged. Your Lordship.
Item number 3.
Number 3.
Item number 3.
After some time. I4.
Item number 4.
There's a caveat in this case. We have served the notice also.
Caveat by whom?
By Mrs. Nauru, my lord.
Lordship, before my learned senior start, let the matter come out at the end of the boat, Your Lordship.
What's the matter about?
My lord, what had happened is that I have instituted a suit against the respondent. She had taken a loan from me, and on her failure to repay the loan, she had executed a sale deed, my lord. But she is still staying in the suit premises. So I have filed an application for deposit of the rent, both of the tenant as well as the respondent. The lower court refused to entertain my application, my lord, saying that the sale deed is a registered sale deed on top of it, my lord, saying that the registered sale deed have to be proved by way of evidence, my lord. So that's the only case, my lord.
Yes. You're a caveator?
Yes, Your Lordship.
Yes, see caveat,
143
petition number 143 to so. Mr. Pala is present on behalf of the caveator. Caveat stands discharged. In the main matter, heard Mr. El Karim, counsel for the petitioner. As Mr. Palas entered appearance, no further notice required. Records necessary?
My lord.
Yes, records we call for this matter admission hearing on reopening.
My lord, the interim order.
Interim order, the courts, civil courts will be closed now only.
Yes.
Item number 5.
You have corrected the cause title.
My lord, with lordship permission, we have corrected, my lord. We have corrected. My lord, the pre-fact of the case, my lord, we are challenging the action of the respondent. My lord, we applied for the license, and even the statute do not require for NOC from the local authority. But for the sake of my lord, the license for the bar, license for the bar, my lord.
Not required this from the vicinity.
NOC is not required. Opinion of the vicinity is required.
Exactly.
And the collector has, DC has done all these things, and even local authority has issued an NOC, and pursuant to the license was granted to him. Now, only he needs to obtain is the permit to leave the liquor from the warehouse. Now, before the DC issued these permits, the local authorities informed the DC that they revoked their NOC. And in view of that revocation, the collector refused to grant the permit till today. Therefore, we are assailing the action.
Means firstly, you had applied the NOC is given by the by this respondent number.
My lord, page number 26, my lord, is the NOC.
Where is this bar?
It is in Nongthamai, my lord. Nongthamai, National Highway, my lord. My lord, page number 26 is the NOC.
26.
My lord, page 26. And the government approval is the page number 32.
Page 32.
Well, page 32.
Yeah.
Well, and the license was granted page number 33. License was given. It was issued on 15 March 2023.
Since 23 has been issued.
My lord.
The bar is running.
No, it is not yet, my lord. He has developed all the
no, why
bar.
did, since 23 you have not run the bar at all.
My lord, without receiving license, I cannot open the
What is
bar.
the license you say?
My lord, once
you received it in 23, why didn't you start running it?
My lord, without the permits to leave the liquor from the warehouse, my lord, that was the problem.
Then where's the permit?
Well, permit they did not give. Before they give the permits, the Deputy Commissioner informed that the NOC has been revoked.
When you apply to lift the permits?
My lord.
When do you apply for the permit to lift alcohol?
But it pursuant to my application, the approval was given and license also given. And the permit is a process of continuous process only. And the last letter written by the Deputy Commissioner, page number 62, he has written back to the Excise Commissioner to consider my case. That is, in fact, abdication of his power.
No, you say the NOC by the village authorities has been revoked.
Revoked, my lord.
Only on that ground.
Only on that ground. And the my lord, Excise Act very clear.
Where's the Excise Act? Let's see where does it say.
I have a please. My lord. Assam Excise Act 1910 was adopted by the state of Meghalaya, my lord.
No, the thing is that I think for this wine stores and all the vicinity, the people of vicinity,
Yes.
no objection has to be received.
Normally, my lord, if the location is near to the health
Even then, there has to
my lord,
be whether-
education institutions, my lord. I'll please, my lord.
Yeah, Mr. Singhwan.
Will require instruction, my lord, in this case.
Revise instructions.
Yes.
He has invested a lot, my lord. I'm paying 50,000 per month.
My lord, the NOC which was granted earlier, my lord, that has been revoked. Maybe that is
what is the role of the whether on this revocation NOC which has been granted, were you heard before they revoked it?
No, no opportunity given. And lordship, if lordship kindly says rule 182, it is very clear. Even religious institutions. But I'm sorry if I can just place my book, my lord. 182, madam. Normally, where it is near to the religious institutions, education institutions, or the hospital, madam.
See this 183 too.
Yes.
That's the thing. Should be located which neighbors object on grounds upon inquiry be reasonable and free from malice or ulterior motive, be resistance from religious education. That is just one of the conditions. But then I've seen that they require some sort of consent from the vicinity, people residing in the vicinity.
But it requires only opinion of the vicinity.
The Shillong has stepped to the shoes of that vicinity. Since the last day, what to do?
I only pray my lordship may issue notice and let them file affidavit, and attempt may be made to dispose of at the admission stage, madam.
Yes, there's a senior counsel assisted by Mr. T. Dakhar for the petitioner. Issue notice. Mr. N. Singhwan, present behalf of 1 to 5. No further notice required. Notice issued to respondent number 6 within 3 days. Yes, list the matter for further orders on the first week of February.
If lordship fix the matter for admission, madam, I'm paying 50,000 per month for the rent only. If lordship make an effort, yes.
Item number 6.
May I please, Your Lordship?
There's a caveat by whom?
There's a caveat by the private respondent. Well, he's the beneficiary of the impugned order.
Yes,
Ahidur Rahman.
Yes, my lord.
Caveat petition number
Respondent number, my lord.
Respondent
8,
number?
my lord. Respondent, my lord. Here, my lord. The state respondent has stopped my salary, my lord. I was
no caveat is respondent number
8, my lord.
Yes,
8, my lord. He was much the respondent number 8.
Just dispose of the caveat.
Yes, my lord.
Then you can start the argument.
Yes, my lord.
Yes,
my lord.
This in the caveat petition. In the caveat petition, stop the caveat is represented by Mr. K. Policy Counsel with so and so, and has been arrayed as respondent number 8 in the connected writ petition. Caveats accordingly stands discharged. Yes. Yes. Now you can see. What do you want to say,
my lord? Yes, my lord. The I was appointed in the year 2002, my lord, by the first managing committee in the school, my lord, Puskunipara SSA LP school, my lord. Thereafter, my lord, I joined my service.
You were appointed since?
Since 2002, my lord.
2?
Yes, my lord. Then my service was approved by the SDSEO Dadangri in the year 2017, my lord. Approved, my lord. Then I was continuously in the service, my lord. Then the direct transfer of salary to the account came into existence, my lord. Then the salary was accordingly transferred into my account, my lord, time to time.
From?
My lord, I have annexed the bank statement at annexure 9, my lord. At annexure 9.
You're a sanctioned teacher.
My lord, yes, my lord. At annexure 9, my lord, page 32, my lord. It starts from page 32, my lord. That is from the, my lord, bank statement from 1st January 2023 to 31st March 2024. Up to 31st March 2024, my lord.
You've been paid?
Yes, my lord. Prior to that also I was paid, my lord, by the state respondent. All of a sudden, my lord, in the month of April, my lord, my salary was stopped. by the state respondent. Then I filed representation to the concerned authority, state respondent. Then the DMC, my lord, DMC has not issued. I filed representation before the DMC, my lord. Yes, DMC West Garo Hills, Tura. Then I filed another representation to the, my lord, director of school, my lord. Thereafter, director of school had issued order letter to the DMC to look into the matter with regard to the release of the salary. Then, my lord, DMC has conducted an internal inquiry. In pursuance to that, my lord, the DMC has write a letter, in the impugn letter, to the director of school. One letter, one order, my lord. In that order, the DMC has held that the managing committee has passed a resolution and the matter with regard to the salary of the petitioner is amicably settled, my lord. But
amicably settleable how?
My lord, that only the state respondent has.
Now, is 2005, you said?
2002, my lord.
2002.
Yes, my lord.
Now you've been paid the salary through your sanctioned teacher, you said?
Yes, my lord.
Just I'm accepting your submissions only.
Yes, my lord.
Then starting 24, your salary was stopped.
Yes, my lord.
Without any reason?
Without any reason, my lord.
You filed representation?
I filed representation.
Amicably settled. Where is that?
Yes, my lord. Representation, my lord, yes.
No, where is it amicably settled?
Yes, my lord. At annexure, my lord. At annexure 52, my lord.
52?
Sorry, my lord. Annexure 16, page 52, my lord. May I read, my lord?
Yes.
In reference to the directive issued by the State Project Director SIMAM SSA Meghalaya Shillong White letter dated 29 August 2024 and in accordance with the findings of the inquiry report dated 18/9/2023 from BMC Shelshala as well as the resolution passed by the school managing committee.
See, one thing, Mr. Hassan, amicably resolved means between you and the respondent number 8 is been resolved.
Yes, my lord, it is held in the impugn order, my lord. But the matter is not resolved, my lord. Without my concern, the inquiry which stated in the order, my lord, neither I being notice was issued, no paper was submitted behind my back, my lord. That is the issue, my lord. And the resolution which is mentioned in the impugn order passed by the managing committee.
It's not understandable. How, if you've been working since 2002,
yes, my lord,
this person will come? When was he appointed?
My lord, the respondent number 8, he is appointed in the year 2013. He joined in his service in 2014 January, my lord.
So how come he's taking your place?
My lord, that state and the managing committee.
So your salary is gone to his account as per the as per the settlement.
Yes,
he says that under now salary of the other was not to be processed through PFMS mode.
Yes, my
lord. Where the office communication date 28/11/2023 referred to here?
My lord, that is, my lord, it's not our possession, my lord.
What do you know? Not your possession.
My lord,
some communication where
lord,
you've been. See, this is 2023. That time you're still getting a salary, correct?
Yes, my lord. 2020.
So if at that time it was already instructed to process to the salary to his account.
My lord, this 28/11/2023 letter, it's not in my possession, my lord.
Yes.
All of a sudden, this in Garo Hills, most of these schools, these things happen, my lord. In SSA, UP and LP, my lord. Founder teacher working from 10-12 years, then all of a sudden new person appointed.
They're not
and new managing change of managing committee.
That's what happens normally. That's why they find out one fine day that he's not a language teacher, he's not a...
My lord, that is exactly happening. A new change of committee, my lord. Change of new managing committee. They were appoint another teacher, fourth teacher in the name of...
What is your case?
Let's, if I may just draw your lordship's attention to page 50 and extra 15.
Page?
50? Page 50, my lords.
Yes.
The first thing is, my lords, my friend has not annexed the inquiry report dated 18/9/2023, which would actually show what was the inquiry. We can find out what is the inquiry, my lords, on this. If your lordships kindly have a look at paragraph 2. On 18/9/2023, the block mission coordinator submitted a report highlighting anomalies in the appointment and joining of Shri Azarakuman Pradhani. The report indicated that no approval order was issued by the then District Mission Coordinator and Joint Director of School and Literacy. Additionally, a letter dated so-and-so was received from the headmistress and ex officio member of so-and-so requesting the transfer of salary through PMFS to Adhiur Rahman. Consequently, a letter dated so-and-so was issued by the school managing committee seeking clarification and submissions of the final list of teachers with a resolution for salary payments through PMFS. Following the resolution dated so-and-so, the school managing committee of so-and-so, which named Ahidur Rahman as a sanctioned teacher and requested the transfer of salary through so-and-so, a letter dated so-and-so was issued to so-and-so requesting registration of Ahidur Rahman for salary and payments. Despite this, Pradhani continued to receive salary until March 2024 from the BRC office. A necessary clarification was sought. As clarified in the letter dated so-and-so by the block mission coordinator, the salary payments to so-and-so until March 2024 were made in error. However, so-and-so withdrew the amounts paid to them. From so-and-so, salaries were paid to Ahidur Rahman as per the inquiry report of the BMC and the clarification of the school.
So how are you appointed then?
My lord, as per this letter, my lord, they have conducted an inquiry after the director
They will have to come with an affidavit.
My lord, yes, my lord, because they have not issued any letter, my lord.
Yes, then it constitutes a petitioner issue notice. Who's appearing for the state respondents?
1 to 5.
Mr. Kibar Saji, Leonard J is present, except notice on behalf of response 1 to 5. Respondent number 8 is represented through caveata. Is represented by Mr. K.P. K. Paul. Notice to issue to respondents number 6 and 7, Mr. Area lists accordingly on so and so forth.
Well, the question of maintainability may be kept open because the prayer and the
raise my affidavits for offence instructions is.
Item number 7.
Highly obliged, ma'am.
My lord, matter pertains to fixation of pay of High Court officers and staff. My lord, similar matter is pending before your lordships. So if notice can be issued and the matter may be tagged along, my lord.
We accept notice, your lordship. Correct, your lordship.
Yes, heard Mr. Philemon Nongri, issue notice. MS T. Yangi, London AAG with so and so present, accept notice on behalf of response 1 to 4. Notice issued to respondent number 5.
This matter has been fixed on 6th of February.
Submitted by the council petitioner that similar matters regarding
fixation of
pay for High Court employees is pending in WPC number 340 of 2024. Stop. This is matter together with WC 340 for next date.
Deeply.
Item number 8.
Lordship, this regarding.
Yes, Mr. Sen.
He's on sanction leave now.
When did the person retire? 4 months only you've come. It's not 6 months, you can understand, take 6 months to process. Anyway, heard so and so, issue notice. Mr. M.U. Ahmed Vice, Mr. Essence present, accept notice on behalf of the sole respondent. List on so and so.
8, 9, 10, your lordship.
8, 9, 10.
11.
What is this?
May please, your lordship.
Nokma?
No, my lord.
This is not maintainable, my lord, the petition.
No, my lord. We're actually challenging the order passed by the assessment settlement officer, my lord, and
Assistant Settlement Officer. Then
yes,
this is a revenue matter.
and thereafter, my lord, it was an appeal was filed, my lord, before the deputy CEM, my lord. There also the same order was passed, my lord. That's why we were before this honorable court, my lord.
Appeal lies before the board, and board is
not constituted, my lord.
The board, it is the CEM who is acting as the board, my lord.
Where the notification? You have taken out earlier on.
There is, my lord, the law provides.
Also similar thing.
Yes, my lord.
You examine Mr. Movement.
Lordship.
Why should you lose the ladder of appeal?
Lordship, but as per my instruction, the board has not been constituted, my lord, in the district council. That is why we are before this honorable court, my
It is
lord.
the CEM who act as the board, my lord.
The board has to be.
Is the suit pending?
No, we have not filed any suit, my lord. Here, actually, what has happened, my lord, if I just come to the merit of the case, my lord, that the petitioner is the Nokna daughter, my lord. And by way of inheritance, my lord, she is entitled to the property left behind by the parents, my lord. So thereafter, my lord, she was in ownership and in possession of a plot of land, my lord, measuring about 8 bighas, situated at Ronghon, Edinburgh, my lord. Thereafter, my lord, the youngest sister, my lord, she, in the year 2022, started earth cutting and like felling of the trees, my lord. So she interfered into the of her action, my lord. Then thereafter, like she came to know that a patta was fraudulently obtained by her, my lord.
By her aunt?
No, by the sister, my lord. Was fraudulently obtained by the sister, younger sister, my lord. In view of a Nokma document, my lord. That Nokma document also, my lord, in the year 1975, the Nokma himself has reiterated, my lord, that the property belongs to the.
But then what application did you file before the settlement officer?
We filed an application challenging the cancellation of patta, my lord.
You have to file a suit, I think.
Cancellation of the patta, my lord. Then thereafter, like.
Where's the order?
My lord, order is at page 49, my lord.
Application. The first order.
The translated copy is at page 54, my lord. If I may be allowed to read, my lord, this one.
Yeah.
This case has come up on the petition filed by the complaint Srimati Herinita R. Marak and others against the alleged periodic patta and issued in favor of Srimati Bonji R. Marak, defendant. In a complaint petition, Srimati Herinita R. Marak prayed for cancellation of PP patta number 28, DAG number 2930, measuring an area of 8 bighas, which was issued in the name of Srimati Bonchira R. Marak at Ronghon, Edinburgh under Mosa number 216. I've summoned both the parties and asked them to settle the above matter outside the court and to bring the resolution of the meeting in the court to the court on the fixed date, but the complainant had remained absent for a number of consecutive dates. However, I pursued the materials documents available in the office records, and it reflects that the land in question belongs to Srimati Bonchi Santura R. Marak, as it was settled in favor of the above defendants with consent of the Maharis and Nokma document of the Ronghon, Edinburgh on 21st/10/2011. More, I've also seen that the present case is civil in nature. I therefore advise the parties to approach in the proper forum to establish the right title interest over the aforesaid land, my lord. Thereafter, we challenge this, my lord, before the Deputy CA, my lord.
See, the thing is that you challenge it, but even the finding is that based on a Nokma document, they have upheld the.
No, that Nokma document, my lord.
Then if that is the root of the matter, then you have other remedy.
No, my lord. Under section 141, my lord, of the Assam Land and Revenue Regulation Act, Regulation of 1886, my lord, which the District Council has adopted, my lord. It says that the inquiry should be conducted and evidence should have been taken, my lord. But evidence was not taken, my lord. If evidence was taken, it would have transpired that
Can you file for the board revenue?
My lord,
but there is no notification, my lord, that.
Page 299, my lord.
I did Garfield's green book.
Yes, my lord. 299, my lord. Page number. Section 4, clause 4, my lord. Insertion of new section. Section 4 below Section 3 of the Principal Regulation. Any reference to the Board of Revenue in the Assam Land and Revenue Regulation as amended shall be constituted as the reference to the Chief Executive Member, my lord. So they can file before the CEM, my lord.
You file it, Mr. Withdraw.
No, withdraw it, my lord. We file it before the chief.
The EG movement submits that as there is alternate remedy available in the form of appeal that can prefer before the Board of Revenue, before the Chief Executive Member who sits as the Board of Revenue. He may be allowed to withdraw this application to prefer the same before the appropriate forum. The prayer is allowed. Matter stands closed to withdraw with liberty as prayed.
Item number 12.
This is a matter regarding a prayer for regularization which was rejected. At this stage, I'm just praying for a notice. Your Lordship's let them file an affidavit.
Kim understood? No.
No, no.
I thought
Regular.
Mr.
Accepting notice.
Here, policy and council assisted by issue notice Mr. J. Thaba.
Yes, Lord.
Present on behalf of all the respondents, no further notice required. This applications, this so and so for instruction of the affidavit is.
That's valuable.
13.
What is this? Yes.
May please, Your Lordship. Your Lordship, this instant writ petition is pertaining to the impugn order passed by the CEM, Your Lordship. GHEDC, that is in page 65, Your Lordship, and extra 10.
Yes. This is Nokma matter.
Yes, Your Lordship.
Yes.
63, my lord.
63.
Yes, my
Your Lordship, may I read the last part of the order, Your Lordship?
Yes.
Since there is no presumption that delay is occasioned deliberately or on account of culpable negligence or with a maleficent intention to gain any benefit out of this delay, therefore prayer for continuing the above
Where are you
delay.
reading from?
It is on the
Last para
fourth
10.
line, my lord. Last fourth line.
65.
Yes, Your Lordship.
Page 65.
Yes.
Or on account of culpable negligence or with a maleficent intention to gain any benefit out of this delay, therefore prayer for continuing the above delay to file an appeal against the order dated 13/4/1983 is allowed. Based on the above observation, this petition is therefore disposed of accordingly.
Against an order 13/4/1983.
Yes, Your Lordship.
Yes, my lord. We have condoned the delay only, my lord. The appeal has not been decided. The appeal is still pending, my lord.
Your
Only
Lordship.
we have decided under condonation application, my lord.
Then there has
Your
to
Lordship,
be
there
very
was-
compelling reasons for for condoning.
my lord, I will take
83 now is
yes, my lord, I will take instruction, but because the matter is still pending, my lord. They are not out of the suit or out of the matter, my lord. Only, my lord, delay has been condoned.
yes, you are praying for interim orders.
Yes, Your Lordship. Your Lordship, I
Only
pray.
only against this order you've come.
Yes, Your
Condoning
Lordship.
the delay.
Your Lordship, and to state the appeal, Your Lordship, pending before the CEM, Your Lordship.
How is it possible today? Or what circumstances was this delay condoned?
That is what, my lord.
Because even then,
petition has to be examined, my lord.
discretionary action usually higher courts interfere, but if on the face of the record it looks a bit.
Probably a good reason was given before the CEM, but for that, my
No
lord, the
reason was
petition.
given.
Probably, my lord, that is why this order hasn't passed.
Other kind of reasons were given.
My lord, what I will pray, my lord, is this, my lord?
We'll stay this order, yes.
My lord, if this application is stayed, my lord, then the entire appeal will be stayed.
But MSEDC Eminent Counsel for the petitioner. If you notice, Mr. SD is present and accept notice on behalf of the respondents number 1, 2, and 3. Notice to issue to response 4 and 5 within 3 days by the state AD. Stop. Next time, MSEDC Eminent Counsel for the petitioner has submitted that the petition is directed against an order dated. What is
7/8
dated?
7/8/2024,
whereby the chief executive member in each ADC. How come the two numbers?
Your Lordship, they had appeal regarding the order.
No, how do the order the pass in which 7 in which case? What's the number of the case?
In this case, Your Lordship.
Which
In
case
this
number?
case, number 41 of 2023.
41A or this one stroke
Your
AC
Lordship.
or
My lord,
2023?
if I'm just permitted to apprise this honorable court, it appears, my lord, there was two order. One order is of 13/4 to 1983.
Where's the order? Oh yes, 13/4/83.
83.
That is what
That has been, yes. And there was another order, my lord, by which, my lord, the EM's order has been challenged. And EM order is of 2023, my lord.
No, we will refer is the last appellate order. Yes, Honor. 24 passed in GCC Miss case number 41A/C of 2023, wherein a delay in preferring an appeal against an order dated 13/4/1983 has been condoned. Stop. Next paragraph. Stop. Not same paragraph. She prays that as the delay is of a substantial period, amounting to how many days? Of how many years?
14,755 days.
Over 14,000 days.
14,000.
Of the impugned order is liable to interfere with. Yes, next paragraph. On hearing the general counsel of the parties as also of controlled parties emphasize, it appears that a case has been made out for interim orders at this stage. In view of the at this stage, stop. Accordingly, next sentence, the order dated 7/8/24 shall be stayed, shall remain stayed till the next date. Yes.
I may be allowed to file a small affidavit.
Yes, list on so and so for instruction to affidavit and for service on the private respondents. And for report of service on the private respondents.
14.
But on this matter, we are challenging the action of the respondent collector, reviewing the award passed by him. What happened? Section 11, Section 19 declaration done, and he fixed the award on 4th May 2023. Award was fixed under Section 23 of the new LA Act, and though the approval from the government is not required, unlike the previous Repeal Act, he sought the approval from the government, and the government has accorded its approval.
Approval for?
Approval for the amount of compensation amount.
You awarded?
Yes, awarded amount. Then after government has approved it, my lord, what happened on the 7th November 2023, it appears that there was a meeting for reviewing the award, saying that the award fixed by the collector is in the higher side, less than the probable estimates given by the Ministry of Road and Transport. Now, in view of that
pressure, market rate.
Market rate
is higher than market rate.
Yes, so as per the market rate, he has fixed. Collector has fixed, and she placed that approval to the government for approval. Government approve it. Subsequently, government said in the meeting again and said that no,
who was the entity? The NHIDCL.
NHIDCL is the implementing agency.
Is a Western bypass.
Western bypass method.
Western bypass means from Barapani.
Barapani to Nostra inside. And in view of that pressure, it appears that collector perhaps review its order, review the award, and give a compensation lesser than the amount she already fixed earlier. So today we are challenging this the action of the collector.
Have you received part of the compensation?
Part payment we have received.
You received the entire one that was no. Now when the it was fixed to the collector and approved, any compensation released?
A compensation was given, my lord. Award notice was served to us on 26th February of this year, fixing 4th and 5th March. So the landowner came to Shillong to collect the compensation, and they found that it is inadequate comparing to the approval given by the government. Then the officers say they know there was a proceeding for review. So since the issue for review will be decided, if extra compensation required to be paid, will be paid. But as of today, this is the amount. So they received that one. Now subsequently through RTA, they come to know that there was a review.
Yes, Mr.
Your Lordship, two things, my Lord. The petitioners have accepted the award, part amount of the award, and they are agreed with the determination of compensation under the award. So they are.
But this question of review, the first time.
Question is, my Lord. Question is that what was the question is award, my Lord. Before award, if there are deliberations.
I'm not really familiar with this new.
Only two sections are there.
One thing now, suppose the collector has
given X amount.
Given X amount for
yes,
this
and they are not
right?
and they are not satisfied.
And that usually is the tentative amount. If they agree, if it's inadequate, they have recourse to other remedy.
Reference.
That's different.
Yes.
But what this court should do now, they have been, the amount has been fixed naturally they won't have any quarrel if the amount is a bit high fixed by
Yes,
the collector.
yes,
So
Milord.
they're expecting that amount.
Yes, Milord.
Now reviews were conducted
Now,
unilaterally.
the award,
on what materials?
what
is
my
the,
friend is saying is review, Milord, is not correct. There is no concept of review in Land
Right,
Acquisition Act.
right.
The concept is award. If there is an award,
Yes.
and my friend's client are agreed with this award or the amount mentioned in the
They have
award,
recourse other
and they
remedies.
have the recourse under section 64 to approach the collector, my lord. So therefore now they have to show what is the award, and what, if your lordship will say, in the prayer he say that they later on under RTI they came to know that there was deliberations about, because before the award is prepared, my lord, there are n number of deliberations between the government authorities. So there was
See,
a
the collector did not fix amount early, but they have. Where's the other see that?
Yeah, your lordship kindly see the award.
Let us see the
Award is the only statutory thing in the law.
My lord, may
Nothing
come to
else is
page
there.
number-
And under the RTI, if
Page
my
number
friend is
77.
producing deliberations,
Yes.
those deliberations have got
76.
no meaning.
76 is the award, my lord.
Kindly see what is the
Page
word
number
used,
76.
draft. 76, my friend is
Well, I'll
reading.
come back.
It is only draft, my lord.
There is no concept of draft under the new act now.
No, because they...
76 is the award passed by him on 4th, 5th. And accordingly, page number, the next page is 77. Collector sought the
Prepare
approval.
a draft vote accordingly, adding the mandatory solution 100% under section 30 of the Act. along
Where is
with
the,
the interest.
let him place the award, my lord, and he saw that.
And thereafter, my lord,
Where's the
page number 81. Lordship
The
kindly.
award.
Well, award statement, my lord, page number 78, 79. Well, till 80.
Since it's as per the rate that you're happy with.
Yes, we are happy with. We have no quarrel with. And page number 81, Lordship, can you see?
Award statement.
My lord.
Yes.
Page number, government has approved it.
I page section 33. I know the new act.
Your lordship kindly see 63 and 64 of the act. See, section 63 and 64 of the act.
23 first.
But 23, Lordship.
New act. 1213 act.
And 37, section 37, 63 and 64, my lord. 3 sections.
One second.
Section 37, your lordship kindly
Section
see
23 is the award he passed.
No, whether this is in terms section
30
23.
no.
It's page 78.
What?
23C.
the finality, my lord,
73
reaches at 37, my lord.
says
Finality of
On
the award
this
is
of
at
fees
30 section
or
37, my
any other
lord.
day to which the inquiry has been adjourned, the collector shall proceed to inquire into the objections, if any, which may person interested has stated pursuant to the notice given under section 21, to the measurement made under section 20, and into the value of the land at the date of the publication of the notification, and in the respective interests of persons claiming the compensation and rehabilitation or resettlement, shall make an award under his hand of
Okay.
their
Now 37. What is
37, the award shall be award shall be filed in the collector's office and shall accept as hereinafter, provided be final and conclusive evidence as between the collector and the person interested, whether they have respectively appeared before collector or not, of true area and market value of land and assets attached thereto, solatium so determined, an apportionment of the compensation among the person interested. Collector shall give immediate opinion of a notice of his award to such persons interested who are not present personally or through representative when the award are made. Award is made, my lord, and after award they have collected the amount also, my lord. After collecting the amount, my lord,
where's the award where the less amount was given?
and 63, kindly see 2 more sections, section 63 and 64, my lord, of the legal, the statutory scheme, my lord.
Yes.
No civil court other than High Court under Article 226 or 227 of the Constitution or the Supreme Court shall have jurisdiction to entertain any dispute relating to land acquisition in respect of which collector or the authority is empowered by or under this Act, and no injunction shall be granted by any court in respect of any such matter. 64. Any person interested who has not accepted the award may by written application to the collector require that the matter be referred to by the collector for determination of the authority, as the case may be, whether his objection be to the measurement of land, amount of compensation, the person to whom it is payable, the rights of rehabilitation, resettlement under chapter 5 and 6, or the apportionment of the compensation among the person interested, provided the collector shall within 30 days date of receipt apportion make the reference to the appropriate authority. So they have accepted the part amount, my lord, if they are agreed with the review and they can go and challenge before appropriate authority.
Where's the new amount?
My lord, the new amount under the RTI lordship kindly come to page number 347, my lord. Page number 347. Now, under RTI, collector has disclosed the award for compensation, land compensation is, my lord, 479, 4609, and 473. Is a complete reversal of the original award. I don't dispute the argument advanced by the learned AG.
47?
My lord. Page number 347, 347, lordship. At
Yes,
the
you have
bottom.
recourse. Now, the thing is that, you see, whenever it comes to compensation, the only right you have, if it is inadequate or measurement or whatever, that's the only thing.
Well, madam, I apologize.
Apportionment.
Well,
so the thing is that if we have any quarrel with any part of the award, notwithstanding anything that's transpired in the,
in making the award.
meanwhile, making the award, that you have remedy in section
Well,
64.
my lord, I don't dispute with that.
Then?
Only my grievance, my lord, if the collector give me 10 rupees, and if I say that no, 10 rupees is less,
Then
it
that'll
should
go
be
to
15,
reference
then I
court.
should go for reference court.
You
But
know,
my
now
grievance is, my
reference
lord.
court, you'll say that,
My
look, then let the collector come and use evidence on what basis he
no.
fixed a bigger amount.
Yes, my lord. My grievance is, my lord, once collector fixed it 10 rupees, and he reviewed by himself and reduced to 7 or 5 rupees, then I don't need to go to agitate before the reference court.
Do you think that's arbitrary action?
My lord, section 33 of the Act itself is very clear. The power of review. Lordship, kindly look into the section 23.
23?
Bear with me. Yes, 23, 33 of the...
33.
Yes, 33.
Okay, you file affidavit.
Let them file affidavit,
But
madam.
that's the only point. That
Yes.
only court will see whether
Yes, that is a narrow issue.
yes. You can the corrections. This is regard to corrections made by collector.
Yes,
33.
yes. The decision is also there, madam.
And 37 gives the finality to the award, my lord, and challenge mechanism is laid down in
33
section.
is very important, madam.
It's a self-contained
He is
code, my
allowed to
lord.
collect the clerical
See, but the thing is that suppose you go to the collector for making a reference, and before saying for reference, he make corrections. That's permissible.
My permissible, but he cannot order the award.
Right.
But what he has done is he has changed the award.
But Mr. H.L. Sangri, so learned counsel for the senior consultation with Mr. T. Dakhar, issue notice, then Advocate General is present with
1450 connected.
Yes.
Accepts notice on behalf of respondents number 1 to 6.
1 to 6.
1 to 6. What about where Dr. Mozika?
My lord, we will serve copy to Dr. Mozika.
He was here, I think, in the morning. Who's there on his behalf?
We will serve the copy to Dr. Mozika.
Are they
Number
appearing for NHIDCL?
My lord, NHIDCL in other cases, other lawyers used to appear.
NHIDCL, who appears? You appeared earlier on. Dr. Mozika appeared. You have no idea.
I can take
They'll
steps.
appear for number 7, that means. Yes, Dr. Mozika is here. Are you appearing for NHIDCL? Can you accept notice?
Yes. Okay.
Yes,
We'll
Dr.
serve
Mozika
copy.
accept notice
Yes.
on behalf of the
789.
remaining respondents 7, 8, and 9. As such, no further is required. List after vacations on so and so for instructions and affidavit. Interesting point. Whether whether collector can do it.
Yes. Yes.
That
That
is
is the
amount just a correction or whether.
Yes.
Because under
Your
37
friend argues beyond the scope of the act. Correct.
Yes.
37
We'll
is the
satisfy.
finality, my lord. And they
The
have
next item is also similar. Report matter, my lord. Notice may be issued. Same
matter.
respondents.
Same petitioner.
Same respondents. Same award process.
So there is a change in the array of parties.
Yes.
So far as the second matter is
Second matter is 1 to 5
I am entering
1 to
into
4.
appearance 1 to 4, my lord.
and 5 and the rest. Dr.
5
Mozika.
and rest will be there.
5, 6, 7 is 1 to 4.
So you have made one less part.
16.
Second GJDC? No.
This is regarding, my lord, land was given by us, my lord, for construction of Ampati Studium, my lord. And then, my lord, a promise was made.
Studium?
Yes, my lord, Ampati Studium, my lord. And, my lord, a promise was made, my lord, that a job will be given to the people who has given the land, my lord. So only notice maybe.
Yes.
Lordship. I'll have instruction, Your Lordship.
But Mr. SD, the consultation issue notice, Mr. Industrial AG with so present except we have all respondents before us required vacations and so on and so forth.
Apply, Your Lordship.
17.
Please, my lords. Let's hear what has happened is there is the school, my lords, and there has been some issues regarding the managing committee of the school. There is a direction by the district magistrate regarding a magisterial inquiry that is to be made with regard to the management of the school. Now, in the meantime, my lords, the school had made an advertisement for appointment of an assistant teacher. Some complaints were made and an order was passed by the government, my lords. I'll just take your lordships to the orders passed by the by the government at page 70 annexure 9.
17.
70, my lords. Now, this district school education officer passes this order, my lords, on the 28th of November 2024.
70.
Yes, my lords.
Yes.
Consequent to so and so date, this is dated the 28th November, my lords. Consequent to letter dated so and so, issued by Director of School Education and Literacy Meghalaya, the process of recruitment of appointment for assistant teacher Rajabalaya, advertisement on 26 November 2024 in Shillong Times newspaper is hereby kept in abeyance until further orders. Further, Secretary of Rajabala School is hereby instructed to publish the postponed order from your end. Now, this is the order given by the government. Now, what the school managing committee does is that annexure 10, my lords, they issue a corrigendum. And they say, my lords, in partial modification of the previous advertisement dated 27 November 2024, published in Shillong Times and Saltini Janera daily newspaper, last date of submission of application for the post of one assistant teacher 16/12/2024 till 5 p.m. Application must reach the office of so-and-so and personal interview will be conducted on 9/12/2024 in the office chamber of so-and-so. So there's a categorical direction by the government, my lords, that it has to be kept in abeyance.
So does advertisement the school?
The school managing committee, my lords.
Yes,
Limited issue.
Lordship, it appears, Your Lordship, that the government has kept it on hold.
Government is conducting a magisterial inquiry, my lords. Now, these people are proceeding.
Mr. K. Policy Counsel for the petitioner, assisted by so-and-so, for the by so-and-so, stop Mr. Andy Shulai, the AG is present and with so-and-so on behalf of respondents number 1, 2, and 3. Stop notice issue to the remaining respondents. Next paragraph. The grievance with petitioner is that though the petitioner is aggrieved with a corrigendum dated 14/12/2024 issued to an advertisement dated 26/11/2024 for recruitment or appointment of an assistant teacher in Rajabala Higher Secondary School, Rajabala. The Senior Council has submitted that the said corrigendum is in violation of an order dated 28/11/2024 issued by the respondent number
3, my lords.
3, wherein the advertisement dated 26/11/2024 has been directed to be kept in abeyance until further orders. He therefore submits that praise that some interim orders that praise that the corrigendum be stayed in the interim. Next one, Mr. N.D. Shulai, the AG, for the respondent 1 to 3 submits that it appears that an order has been issued to number 3, but however the corrigendum has been issued. He therefore concurs submissions made by the learned senior counsel. Next paragraph, having heard the counsel parties, having heard and examined the materials, it is noted that the submission by the senior counsel is correct in as much as there is a categorical order dated 28th November 2024 for keeping the advertisement in abeyance. But this is 26, this is 27 in the corrigendum.
Milords, it should be 26th. It should be 26th, Milords. The order is 26th. There's no advertisement on 27th.
Oh, no.
No, there is no date.
The current order 28/11/24, keeping the advertisement in abeyance. But however, it's seen a corrigendum issued prefixing the date for the submission of application stop. But therefore, prima facie case has been made out for passing for some interim orders. The corrigendum it is so and so by state. Dated when?
Milords, this corrigendum is dated 14/12, Milords.
2024. Shall be state until the next date. So this
Only the question of locus may be kept upon your lordship.
Locus or who?
Lordship, the question now, who is he, your lordship? What is contender for the post?
Okay. Before Mr. Andy Shulai, whoever has a parting shot, no, forget. Just a
I'll raise that, your
as
lordship,
a
at the
parting
time.
submission has submitted that the locus of petitioner may be examined on the next date.
Oh, lordship.
Yes.
18.
Yes.
Item 18 and 20, my lord, or similar matters, my lord.
18 and 20?
Yes, my lord. I'm one bidder who's been disqualified in the technical bid, my lord. And Mr. Shilla is for the other one. That's item 20. Now, my lord,
has the bid been settled?
Yes, my lord. Yes, my lord. My lord, this is the second round, my lord. I'm before your lordships. I've been disqualified on two grounds, my lord. One is the trading license, which your lordships had made an observation, my lord, in the previous round, that it is consequential. If your lordships kindly have your order. Your lordship's order is at page 67. This is 14th of October.
67.
Page 67 and extra 12. 14th October, my lord.
Yes. Yes.
So your lordships passed a detailed order. I had, my lord, in this particular writ petition challenged these conditions of, my lord, trading license and other conditions, my lord. Now, if your lordships kindly have page 77, para 15, my lord.
Yes.
It reads, my lord, the other contentions raised as the product not being under the list of items reserved for purchase of micro small enterprise is not significant to vitiate the tender process in any manner, as there is no restriction in the manner of procurement of authorities' products not listed in the said list. Now, what is important is here, my lord. Further, the contention with regard to trading license is not relevant for consideration, as the same is consequential factor on the bidder being eligible or awarded with the contract, my lord.
Okay.
I have been rejected on this ground, my lord. Firstly.
On this grounds?
Yes, my lord.
This
In the
ground
face of this order.
Yes.
In the face of your lordship's order, my lord, I have been rejected. That is number one, my lord. Now, your lordships, kindly have page 79.
Yes.
This is, my lord, the fixed deposit.
Now, what connection does it have?
Yes, my lord. This is the second ground on which I have been rejected.
You said only one ground.
No, my lord, two grounds. One is the trading license and one is this call deposit.
Okay.
Now, this is a fixed deposit, my lord. On top, my lord, it has been certified by the bank that the beneficiary is the director of housing. Now, this was, my lord, somewhere in the middle of the page, your lordships will see. It was, my lord, dated 9th of October 2024, because the tender was submitted on 15th of October, my lord.
Where's the date?
My lord, date is in the middle of the page, my lord.
10 or 9, maturity date 9/11.
Date of issue, my lord, date of issue.
Date of issue 9/10, okay, 24.
Yes, my lord. And then in the column below, my lord, on the right side, in English, my lord,
Yes.
for deposits issued of 1 year and above, deposits will be renewed for 1 year at the so-and-so date, and if not instructed otherwise. So it means, my lord, if it matures, it will automatically renew, my lord. Now, my lord, at page 80, annexure 14, this is a clarification given by the bank, my lord.
Yes.
It reads, my lord, the subject is, my lord, clarification on premature withdrawal of deposit amount. It has been addressed to us, my lord, and a copy at the bottom is to the director, my lord.
Yes.
It says, my lord, this is to confirm that deposit account number so-and-so of rupees 1,39 and 30,000 is pledged in the name of beneficiary, Director of Housing, Meghalaya, Shillong, on 9th of October 2024 for a period of 25 months valid till 9th of November 2026 by so-and-so. Upon request from Manaxia Aluminum Company Limited, it is hereby clarified that if our bank gets any written instructions from the beneficiary of deposit that is Director of Housing, Meghalaya, Shillong, at any date between so-and-so, then we shall release the funds of rupees so-and-so in the name of the Director Housing, Meghalaya, Shillong. Also, it is clarified that once
what is the criteria in the for this one in the tender document?
Yes, I'll just take your lordships. Now, if I take your lordship to the tender document, my lord, which is at annexure 2, yes, annexure 2, page 16, is the NIQ, my lord, notice inviting quotation. Now, if I take your lordships to page 19, page 19, in the middle of the page, my lord, B, technical bid.
Yes.
Now, number 2, my lord, number 2 is the requirement. Earnest money deposit in the form of call deposit, oblique bank draft, oblique demand draft, drawn on any nationalized bank payable at Shillong, pledge in favor of Director Housing.
The satisfactory condition.
Yes, my lord. And, my lord, number 8 is regarding the trading license, my lord.
Yes.
Now, my lord, upon my bid being submitted, my lord, they have not, my lord, intimated us regarding any of my deficiency or disqualification, my lord. We have been waiting, my lord, and it was never communicated to us. So, my lord, what we did is, my lord, if your lordships kindly have, page 86, annexure 15.
Yes.
This is, my lord, dated 9th of December, last week, my lord. We write them a letter, my lord, request for status of NIQ. We say, my lord, with reference to the above stated NIQ, we have submitted a quotation in your office on 15/10/24 in 2 bid system and attended the bid opening in Shillong. We were told in the meeting that we will be updated with the status of our bid evaluation in the due course of time, but we were not updated with any status. Suddenly, on 9/12/2024, when we called, we were informed that telephonically that our bid has been rejected. Accordingly, we seek the following information from your office.
Yes.
This is 9th of December, my lord. Now the next page, my lord. Next page, 87, my lord. This is email, my lord. This is an email issued by them, my lord, to the petitioner. If your lordship sees in the middle of the page, 10th December 2024, subject says, my lord, returning of financial bid and call deposit, earnest money, bank draft. So there enclosed, my lord, page 88 along with this email, the attachment.
Yes.
So on 10th, they issue us this email and they enclose a letter dated 4th of December, my lord, which says returning of financial bid and call deposit, earnest money, bank draft. With reference to the subject cited above, I regret to inform you that your firm, company...
So have the bids been opened of the other
yes, my lord.
tenders?
It was already open, my lord, and we were never intimated of our disqualification. Now, if your lordships kindly have, page 90, my lord, last page.
Yes.
On 12th of December, my lord, last Thursday, my lord, they issue us this letter. In reply to my letter, my lord, 9th of December, they say, with reference to the subject mentioned above and in response to your letter, reply to notice inviting quotation so and so. Under reference, I am furnished here with the following information as sought by you. The bidders who were not found qualified by the departmental tender committee are so and so, A and B. I am A, my lord. The first ground of rejection is, my lord, no call deposit, bank draft, demand draft submitted as earnest money as stipulated in the NIQ. Second ground, my lord, trading license submitted is from West Bengal and not from the concerned district council as required under clause 13 of stipulated general terms of conditions, my lord. And your lordships may kindly see the last paragraph, my lord. Second last paragraph, my lord. Qualified bidders. So, my lord, intimation is after they have already opened the bid, my lord. Messrs. Meghalaya Roofing and Messrs. Power Roofing. Two qualified, my lord. And relevant documents can be obtained by filing application.
Yes, Mr. RB General.
Yes, my lord. Lordship, kindly see first aspect what my friend has read out. Your lordship's order. Page 78. Your lordship, kindly see.
Yeah.
Your lordship's order is not correctly read and understood in my humble submission, my lord. Page 78. Further, the contention with regard to the trading license is not relevant consideration as the same is a consequential factor on the bidder being eligible. So, trading license is a relevant factor for bidder being eligible. If he is not having trading license, he is not eligible, my lord. If he is not eligible, my order rejecting his bid is perfect or awarded the contract. So there are two aspects of the matter. Your lordship has not held that trading license is not required at the stage of bidding, my lord, as my friend is trying to read in this order, my lord. Because your lordship...
No, this observation was passed in the context of the earlier...
earlier, it was in the context where...
Because they challenged the NAQ.
And your lordship rejected it.
Yes, rejected the challenge, fine.
Yes, paragraph 14 onwards, if your lordship will see the entire paragraph 14 onwards.
Yes.
After 5 line in paragraph, in the instant case NIQ, though have been amended notwithstanding the fact that reservation and restriction still existed with regard to necessity of registration of use under MIPP and the said clause being founded on the basis of the stated government policy, that is of the promotion of economic environment in the state of Meghalaya, said restriction is therefore justifiable and cannot be held to be arbitrary and discriminatory. The other contentions raised as to the product not being under the list of items reserved for purpose of micro small enterprise is not significant to vitiate the tender process in any manner, as there is no restriction in the manner of procurement by authorities of products not listed in the said list. Further contention with regard to trading license is not relevant for consideration, my lord, as the same is consequential factor on bidding, a bidder being eligible and awarded the contract. So your lordship has in fact held in my favor, not said that these clauses are redundant and not binding on the bidders, my lord. And admittedly, my friend has never challenged this requirement of trading license, my lord. Kindly see the page 17.
17?
17, my lord. And yes.
Yes, page 17.
17, clause 13. Non-tribal petitioners should furnish the trading license from concerned district council / income tax returns along with tender papers document mentioned herein. Admittedly, the petitioner was not having the trading license below, and his reliance in my humble submission on the one line observation, my lord, and that too in my humble submission is in my favor, my lord, in the favor of the government. Your lordship has not held that the other requirements. Your lordship has clearly held that this is required to be modified. Those conditions have been modified, my lord, and so far as trading license is concerned, your lordship has clearly said it is one of the requirement for bidder being eligible. Also, he is not eligible, my lord.
But eligible because of the call deposit?
There are two factors, my lord. Trading license and call deposit. Call deposit also I will answer. So far as trading license, if he is out from the trading license, my lord, I need not go into the call deposit also. If he has the call deposit also, it may not make his case good, my lord. Kindly see call deposit just now, because I don't have instruction, but whatever my friend has read, page 79. Yeah. What my friend is saying, it is a call deposit, but I see it is a FD. If your lordship will see at the page 79 top, yes, and your lordship will see FD account number. I don't know whether it's a FD account is same or call deposit is same. That I have to take instruction, but it is a FD, my lord. First, fixed deposit, and fixed deposit in banking parlance is the call deposit or not. That aspect I need to check, but I need not go into that aspect, my lord. First aspect itself is that my condition required that the person should have the trading license, and he was not having trading license. Therefore, he was rightly rejected, my lord. And your lordship has not held that trading license is not the requirement, and that condition has been struck down. Rather, your lordship has dismissed the writ petition in Manakasia Aluminium Company, and same petitioner, my lord. His writ petition was rejected, my lord.
This is in the face of your lordship's order.
Yes.
Yeah.
Now, how will you see is not what is the difference between call deposit and fixed deposit?
That
Because
we.
Lord, a fixed
And
deposit,
this is a fixed deposit.
a fixed deposit which can be prematurely withdrawn is a call deposit. At any time that money can be called. A fixed deposit. Lord, kindly have that page 79.
I'll file reply these matters, because now trading license issue is also important issue, my lord, and we are coming across this issue in other tenders also.
Has the work started? Supply started? No.
Yes, the work has already been awarded, and they have
Some
made them
protection-
parties also.
Protection has to be given, your lordships. Why?
Protection is there. If they succeed,
No,
they will
no,
get
no,
compensation
no,
damages.
no, my lord.
They will get compensation.
Kindly,
The issue is
Lord,
that,
kindly
my lord,
have-
admittedly on the face of it, he is not having trading license.
my lord, kindly have page 18.
Now he is not having
Conditions of
trading
the
license,
NIQ.
my lord. In all other tenders also, we are asking for trading license from non-tribals, my lord.
40 days of vacations. If your lordships kindly have page 18, clause 20.
First, he has to satisfy the case, my lord, prima facie
One
case.
second. First 20 years, what is it say?
And it's a public
My lord, it
interest
reads, my
project,
lord,
my
in the event of selected
Roofing.
quotationer failing to start the actual execution of supply within 30 days. From the date of placing the order by the department, the work shall deem to have been cancelled. So even the successful bidders will have to execute the work. my lord.
One thing is that
Also,
now when these bids were held, how many eligible bidders were considered?
How many, my lord, those informations?
my lord, kindly have page 90. I'll show you lordships.
How many bidders considered?
Yes, my lord. Page 90, my lord. This is a communication dated 12th of December. Two of us rejected, my lord, at Para 1, Manaxia Aluminium and Miriam Commerce. Miriam Commerce, my lord, belongs to, my lord, two tribals. One Gilbert Dingdo, my lord, and one who's
my lord,
Kurba, my lord.
That I'll
even in their case also, my lord, they have rejected on the basis of trading license. Just a moment, I don't disturb you.
Okay.
Now, if your lordships have the qualified bidders at the bottom, two of them, my lord, Meghalaya Roofing and Power Roofing, and my lord, paragraph.
How many bidders were in the fray finally before the work was who were still considered?
Only two, my lord.
Only four in the entire.
Yes, only four.
Later on, it became two.
Two and two are exactly the same rate, my lord. Kindly have para 3.
And two have been given. Both have been given.
Yes, my lord. Kindly have para 3.
Say that this mega roofing, both the
exact
bidders
same rate
were remaining in the fray were awarded.
Exact same rate, my lord. The rate is also given 7.
No. See, just let's go and understand.
Yes.
Now there were 4 bidders initially.
Yes, my lord.
Like item 20
yes,
is yours, and this roofing and power roofing.
Power
4
roofing.
only.
4 only.
4 in the fray.
Yes, my lord.
And then both have been rejected. Now these 2 have been awarded the contract.
Awarded the contract.
Jointly.
My lord, one unofficially from what I have heard, my lord, one has been given 25% of the work, one 75% of the work. It's totally absurd, my lord.
I'll find out.
This is
my
classic
friend is
case,
not,
classic
what
case
my
of
friend is
cartelization, my
saying,
lord.
what my friend is saying, my lord, at least he should write one line here in the writ petition. I don't have anything. What he's saying, orally so many things he's saying.
See, qualified bidders.
There are 2 qualified bidders.
Exactly, but it's not. But there's no settlement of the work as yet.
No, the work has already been awarded. I am instructed to say, my lord. Work has already because it.
Lord, I've just been informed there's a notification of 2015 issued by the government, my lord, in the District Council Affairs, saying that regarding trading license, it is only a requirement after the contract is awarded. There's a judgment also to that effect, my lord. What's the judgment?
They participate in this bidding process.
So you give both of them. That's wonderful, actually.
Exact same rate, my lord.
Rate has to be same. It can't be more and it can't be less.
Value of the contract?
Lord, 69 lakhs. Oh, sorry, 69 crores, my lord. 69 crores. And it can be extended up to 200 crores.
Your Lordship, kindly see, he is not eligible, my lord, so far as trading license is concerned. And the other case, item 20, what my friend has argued.
I'm sorry, Mr.
protect
I
us.
think there is some orders and
Your Lordship.
See, the thing is that we can understand one bidder has been given. Now 4 bidders are there.
Yes, my lord.
Two are
ineligible.
And 2 are illegal bids, and you split.
They are ineligible. They are ineligible.
Not eligible, fine, but there's 2 bidders.
So now the question,
2 bidders are there, and then
they have
conveniently it's given to
they
both
have
of them.
quoted same price, my lord. If they have quoted same price,
There was no 1 rupee something difference in this
no,
case.
there was no difference because they have quoted the
Like
same
the other
price.
matter.
No, but 50 paisa, 30 paisa.
From the whispers in the market, my lord.
30 paisa difference. 30 in that is OD 30 paisa.
From the whisper in the market, my lord, even the successful bidder,
You know,
one of them is going to
my
approach.
lord, these are all arguments of prejudice. I have seen last 30 years. When you don't write anything in the writ petition, you make all arguments of whisper, street talk outside court. Those are not material on the basis of which court can decide. Only issue which I have, my lord, this is a project, my lord. First, what my friend
Public interest should not suffer, public revenue should suffer.
That is one aspect.
My lord, I've made a statement in my petition that my rate is much more competitive, my lord.
Competitive, please disclose the rate also. Competitiveness is not. So now I'm not. The issue, what my friend is saying, that the rejection is wrong because there is no requirement for him to produce the trading license, my lord. In my humble submission, your lordship has not held so. And your lordship rather has held that this is a consequential requirement for being eligible.
See, Mr. Arvind, if I can say is that there's been instances, that is why notification is there, but I don't.
No, I'm coming.
Because after.
No, I'm coming.
Trading license, you're not going to get the,
Your lordship, now what was happening, my lord, that so far as to what my friend is referring to, that whether at the bidding stage trading license is required or not. In coal matters also, my lord, in all MSTC matters, there is a requirement that you should have trading license before you make the bid. So if you are interested in making the bid, you can go to the district council. This is and in all matters, my lord, not in this case only. In all matters, we are insisting on trading license. And second aspect, my lord, just one more point, my lord. What my friend is saying that in item 20, there is item 20 is a partnership firm. Partnership firm has submitted the bid. Partnership firm.
Take that up. Yes. What your partnership firm?
Yes, my lord.
Partnership firm is non-tribal entity.
Not a tribal entity.
But even then, let them submit if they awarded the work.
Yes, yes. And therefore, they are not having trading license.
What about the rejection? What other grounds?
My lord, I am a partnership firm constituting of 2 tribals, my lord. My lord, we were rejected on 3 grounds. Firstly, the
lordship, see page 90 grounds are here. 3 grounds. Page 90 of the first brief only. Page 90. The first matter.
My lord can come to my petition, my lord.
Right. Yes. Partnership agreement soon not submitted.
Yes.
Detailed technical specification not mentioned.
Yes.
And third is trading license.
Okay, his will be a different footing. Yes, I heard Mr. Phineman Nongri, Leonard Counsel for the petition. In this case only, issue notice, Leonard Advocate General is present, except on behalf of with so and so on behalf of respond. Mr. Shulai appearing here also.
Yes.
Heavy machinery, no. Heavy firepower. So,
entire battery.
Boss Shulai was handling this matter.
Yes, Thomno. So, Mr. The Advocate General is present along with Additional Advocate General, assisted by so and so on behalf of respondents 1, 2, and 3. Was to issue to the remaining respondents within 3 days stop. The petitioner, which is the petitioner, which is a registered company, before this court, assailing the rejection of the bid for supply of
aluminum roofing sheets.
Which have been advertised. Which had been where's that NIQ?
My lord, next to 2.
Next year?
2, my lord. NIQ
which had been quoted by NIQ notice inviting quotation dated 10 September 2024. The learned counsel for the petition submits that the bid has been rejected on two grounds. Firstly, that no call deposit slash bank draft, demand draft had been submitted as stipulated in NIQ, and further that the trading license submitted was from West Bengal, not from the concerned district, as required under clause 13 of the stipulated general terms and conditions of NIQ. It is submitted by the. It has been contended that. The learned counsel has taken this court to the matter concerned the first ground rejection, that is the unavailability of the call deposit, and has where's that call deposit business, and has
page the clause or the
that called the document, bank document,
page 79, my lord.
And has shown and has referred to annexure 13
and 14.
13 and
14, my lord.
And 14.
The bank clarification from the bank
to show for this court that the said call deposit had been created in favor of the respondents. Respond number, the director housing is?
Directors, my lord. Number 3, my lord.
3, your lord, on behalf of number 3. And as such, this clause therefore is satisfied. Stop on the other ground, that is the rejection on the non-supply of trading license. Net counsel has referred to an order of this court passed in WPC number 344. 344. Dated 14/10/2024, wherein this court observed that the trading license is consequential. Is a consequential factor on the bidder being eligible awarded a contract. It therefore submits that the trading license, as per the orders of this court, being necessary only when awarded a contract, the rejection of the bid of the petitioner on both these grounds is unsustainable. It is further submitted that the bid has since been settled.
Yes, sir.
No, that'll be submission of it. It therefore prays for some interim protection at this stage. Next paragraph, Mr. Advocate General, on behalf of the state respondents, has strongly contended that this court, that the document which has been annexed at annexure 13 is not a call deposit, but in fact is a fixed deposit that has been created, and that further the orders of this court nowhere have done away with the requirement of the production of a trading license. He also submits that the bid has since been settled with the remaining 2 tenderers, and as such nothing is for consideration, and if the petitioners agree in any manner, it's at liberty to resort to civil remedies. This further have on hearing submission, letter counsel of the parties, and also an examination of the records of materials as placed. Yes, it is seen as submitted that the writ petitioner has been disqualified as a bidder on the 2 grounds. that is non-furnishing of a call deposit and trade license. It is noted that the document annexed in Annexure 13, though styled as a fixed deposit, may perhaps be taken to be called deposit, which deserves further examination by this court, as also the second ground with regard to the furnishing of the trade license, as to whether the same should have been offered at the time of bidding. As it's been submitted that the bids has since been settled, on query from the court, the Adjudication has apprised, or on a query about the successful bidders, the Land Advocate General has apprised the court that the contract has since been settled with the two remaining bidders.
Respondent 4 and 5.
Namely, respondents number
4 and 5.
4 and 5. Stop. In these circumstances, in consideration thereof, as the matter deserves further examination, and as the scope of the contract is large, involving public interests, wherein any transaction of public revenue should be transparent, it is considered necessary at a stage that some interim orders are passed. Accordingly, until the next date, the tender process, award of supply thereof of the roofing sheets shall remain stayed.
It is subject to the outcome of the petition, Your Lordship.
No, shall remain stayed till next date. Next date, you can satisfy the court that everything is hunky-dory finished.
It's transparent only, Your Lordship.
Respondents still want to file the affidavits.
Notice to the respondents, private respondents.
You already said that.
Oh,
Apply, Your Lordship.
Item 20.
Let it be listed along with this item, Your Lordship.
Item 20 is item 20. Heard Mr. Judicial counsel with the petitioner. Some issue notice. It is submitted at the bar that this matter is on the same issue.
Let it be tagged along with
number. Let us know.
478, if I'm not mistaken.
On this matter together.
Lordship. Apply, Your Lordship.
Petitioner to take steps for serve notice on the private respondents.
Apply.
Item 19.
My Lord, this is the second round of litigation before my Lord.
I think they fell in caveat, one of the...
Who?
Darbar Shnong.
Yes.
Who's Darbar Shnong?
Secretary of
Sharat Darbar?
Yes.
The complainant.
Who's Secretary Sharat Darbar now?
Tobias Tudor.
You were the secretary earlier on.
Earlier, I was earlier on. Not.
And we have served copy to the caveat also.
Yes, you served copy.
We have served caveat. Yes.
What do you want today?
My Lord, I prayed for...
We can't stay the elections, Mr. Chariso.
My Lord, it is absolutely apparent, my Lord, on the face of the record, it is irrational, my Lord.
See, we can't state, you'll have recourse to, where's the act?
Act.
What happened? This is a second litigation or is it the
Second, my Lord. Earlier Lordship accept my petition, directed the council to give me opportunity, so I placed my case. Now they file
we'll just for the start the caveat. You have rated him as respondent number?
Yes. Caveat number 7, my Lord.
Number 7. Seen the caveat. It's caveat petition number 145.
I'm sorry, I'm stand corrected, my Lord. Number 9. Number 9.
The caveat petition.
Number 7 also. I filed as the Secretary of Shala Village.
Oh.
Number 7.
Number 7.
And he has also given us number 9 also. 2.
No, you are see in the caveat.
Caveat is filed by number 7.
By one person only.
Yes, by Secretary of Shala Village. Number 7.
The caveat is represented by Mr. Raghuparsandran, who has been arraigned as respondent
number 7. Man.
And even 9 also, Your Lordship.
Twice.
Twice.
7 and 9.
7 and 9.
Yes, in the connected petition. with according stands discharged. Yes, Mr. Jangri, sir.
My Lord, I may invite Lordship attention to page number 24. This is the first electoral list prepared by the concerned authority, my Lord. And my Lord may kindly see serial number 100, my Lord, serial number 513 at the bottom, page number 25.
500 and yes.
513
Yes.
is the mother of the writ petition number 2, and the writ petitioner is 515.
Okay.
Cannot swear, my Lord.
Yes.
His father's name is, my Lord, Horen Sweat. My problem is that I have adopted the surname of my father, Sweat.
Who?
My Lord.
You are number 514.
My Lord. 515 is the writ petition number 2.
550 repression. Okay, then.
Yes. And his mother is 513.
Okay, mother.
Title of the mother is the car.
Yes.
And now the title of his father is Horen Sweat, my Lord.
Yes.
Now I have adopted the surname of Horen Sweat, the Sweat.
Yes. Why?
My Lord, that is the convenient.
That is the issue, Mother, because this came up as per the Khasi Lineage Act. It's not permissible at all.
Yes. Okay, then.
My Lord, that is the issue. And second, writ petition number 1, my Lord, kindly see serial number 525.
Kohima.
Kohima Dakar is the mother, and the candidate's, my Lord, petition number 1 is the 528.
Okay.
They
Sweat
adopted
again.
the Sweat, my Lord.
Now there are two families, different families.
The different families.
Kohima Dakhar and
Yes,
this,
different families.
Plain Dakhar are sisters.
Different families.
Different families.
Different families.
And they both married Sweat.
Yes.
And
yes.
both the children
Adopted the
father's
surname of the father.
Okay.
Admittedly, both of them parents are Khasi, my Lord. Thereafter, my Lord, behind my back, their names were struck off. Repetition names were struck off.
528 struck off.
Yes, struck off.
And
therefore we.
And also 515.
Yes.
Okay, then.
Then, my Lord, we approached before my Lord, and my Lord order is there, page number 58.
Page number
58. 58. And by this order, Lordship direct the respondent to give opportunity and decide the matter. Page number, my Lord, 61 and 62.
Yes.
Thereafter, my Lord, we approach, and now they pass the final order.
Yes.
Final order is, my Lord, page number 69.
Yes.
69. May I take, my Lord? A short order, with Lordship permission.
Yes.
Persons, the order dated and such passed by the Honorable High Court of Meghalaya in WPCs and such. Notice is issued to all the parties concerned in hearing on the matter was taken up on such. The complainant, who was the secretary has opposed the inclusion of the names of such and such number 2, petition number 1 and 2, and others on the ground that they have not recommended by the Sandhi and are not Khasi as per law, my Lord. Now they never take the plea in their complaint that their names are not recommended by the Sandhi, my Lord. They are not Khasi as per law. On the other hand, opposite parties have stated that their family members have been included in the voter list, and the cancellation of their names as sought by the village darbar is illegal and arbitrary. Section 7, my Lord, for the post of contemplates that it is the Sandhi which should prepare the list of all persons and submit the name in their respective villages which has scrutinized the same. In other words, unless the name of person is approved or recommended by the Sandhi, such persons cannot be included in the voters list. On the question put to the opposite parties as to why their surnames is not in their father, they fail to give any satisfactory reply, and as such, there appears to be some truth in the allegation of the Secretary Darbar Shanong that they do not belong to the Khasi tribe. Though this is not the forum to decide the status in terms of Section 6 of the Wadatar Act and also the Khasi Lineage Act as amended, the objection raised by the Darbar Shanong are justified. In view of the above, the names mentioned below are deleted from the voter list. Serial number 4, my Lord, and number 11. Now they do rightly recorded that this issue cannot be adjudicated.
Candidate also?
Yes. Serial number 4 is the writ petition number 2, and serial number 11 is the writ petition number 1, who is the contestant in the election. He filed his nomination.
Yes.
And according to me, but rightly, they say that this issue, whether I belong to Khasi or not, cannot be adjudicated under this forum, my Lord. Despite of that, my Lord, it is a duty of the complainant to prove that one. If I don't belong.
That stage doesn't come. The only thing is that as per this, we've seen that in the earlier occasion also. Right. As per this Section 6 of the Wadatar Act, then it is a Sandhi that should recommend the voters list.
And
Now, last time when you had come, you said that without you being heard,
yes,
then your name was deleted.
Yes, yes.
Now you become a questionable voter.
Yes.
Right, because your name has not been recommended by the Sunday. So that's the only thing.
My
So now we won't stop the election process.
My,
You can go for the tribunal.
my lord, my brothers and sisters, they are still in the voter list. If the reason adopted by the council is correct,
Where we made a statement.
my lord, it is, if in my writ petition I made a statement. My lord may come to para 8 of my writ petition.
Yes.
However, it is pertinent to mention herein that the names of petitioners' family members still present and appear in the final list. Page number 9, para 8 of the writ petition. In the last paragraph, my lord.
Yes.
But however, it is pertinent to mention herein that the names of the petitioner's family members still present and appear in the final list. Most surprisingly, respondent number 7 has not challenged or made any complaint on the other family members of the petitioner whose name appear in the
Where are you reading from?
My lord, para 8 of the writ petition.
Yes, whichever still reason of mention impunitor, sir. That not mention.
Second para.
Yes.
Second last paragraph.
Yes.
However, it is pertinent to mention herein that the names of the petitioner's family members still present and appear in the final voter list. Most surprisingly, the respondent number 7 has not challenged or made any complaint on the
Well, they're
other
not candidates. You're a candidate, that's why.
Petition number 1 is a candidate, and number 2 is not a candidate. Purely, my lord, effort is to remove me from the fray of contesting election. My brothers and sisters are the voters. They have the right to vote, and they are not allowing me to vote, and not allowing me to contest.
When's the election scheduled?
20, the coming Friday.
Friday.
You can't stop it.
Many in the list, may I just place for lordship appreciation.
Another
Even
7,000
the other
voters.
candidates, other voters who adopted the surname of the father, even whose mother is not even a tribal.
You file election
Yeah,
petition.
So my humble submission, my lord, is an arbitrary action on the part of the
Maybe
authority.
but then at this late stage, we won't stop elections.
May I just pray in that case, my lord, if lord, in my case, lordship make an observation that election to be held on 20 may be subject to the outcome of this instant writ petition.
No,
Otherwise, there will be
once
confusion.
elections are held, then you have recourse to other remedy.
But that I will say, on the face of the record, my lord, it is clear, it is contrary, my lord. How can they include my brothers sisters as a voter and they remove me?
Because see, the section 6.
Section 6
Section
is very
6
clear.
is there. Section 6 is there.
The authority is with the Sunday. District Council here is
So
a
you go
neutral
by
party.
statute.
My lord,
That is why.
and the complaint, my lord, the complaint, that was not the issue. My name was not recommended, that was not the complaint, in the complaint petition. They just simply say that I belong to Karo community. My mother is a Karo community. Though my mother is a Khasi. The complaint, lordship, kindly see, I have annexed the complaint also. Page number, my lord, 55 of the writ petition. That is the only ground.
But last week nominations over.
Yes.
I have also filed my nomination paper is still there.
They normally
It is there.
they filed the
Though they have rejected. I have challenged the rejection order
on the
also.
basis of the court's order. This court was pleased to allow them to file the nominations
Therefore, I
pending
filed.
hearing.
Page number 55.
For that.
The file nomination and has been
And they
rejected
rejected.
also in view of the order passed by them.
Page number 55, my lord.
Yes.
In the last paragraph, my lord, page number 55, after careful perusal by the third party on the intimidation of the secretary and the village elders, it was found that the names of the
Are you
non-residents...
resident of Shella or not? You don't reside there.
I am original, definitely I am
Always
staying
stay there only.
Yes, yes.
Every day.
And they say that belong to the Karo community. Though in their electoral list...
No, this is not specifically you. Just that for name.
That is the common ground they have taken.
Anyway, heard Mr. H.L. Changre is on counsel for the petitioner. Notice issue. Notice issue. Mr. T.T. Dindo, Leonard Senior Counsel. So is present behalf response number
1 to 4.
1 to 4. And the respondents number 7 and 7 and
7 and 9 received by my friend.
7
By my
and
friend.
9, yes, are present by way of caveat stuff. Notice issue to other respondents. Number 3 stop. The grievance petitioners that after this court had directed that after this court had directed the respondent number, that is respondent number one, to hear the complaints of the writ petitioners as to the deletion of the name from the electoral list for the elections to the post of Vadadar of Chella Confederacy. The respondent number one has rejected their complaint on the ground that firstly, the name was not recommended by the Sandy village, and secondly, though not deliberated upon on the question of the surname. Stop. This court on hearing the next paragraph, this court on hearing the counsels for parties and on being apprised that the elections are scheduled for 20/12/2024, and further that the nomination of the writ petition number
one has
since been rejected, is not inclined to issue an interim orders to disrupt the election process, and as such, though the petitioner may have a case on other considerations, it is not that they are not without remedy. And stop. You want to continue? We'll close it now.
Well, we want to continue, my lordship.
With the writ petition?
Well, with the writ petition, my lord.
It become infructuous after 20th.
If you make an observation that election will be subject to outcome, my lord.
No,
it is apparent.
not that.
It is apparent.
See, it's apparent. Things are subject.
It's apparent, my lord.
Without a remedy. Stop. However, as let's say counsel seeks to continue with present petition, list the same after notifications for affidavits or for a report of service on the other respondents.
In my case, if I also make that observation.
In this case, no, Mr. Chan, sorry. We're not going to put any, spike in the entire thing that will cloud the entire issue.
21.
We can't, especially with people on that side, any observation made, it might be misconstrued into 10 different ways, not in different ways also. That's the only thing.
Give it up.
May please, Manoj. This is a miscellaneous application which we've had to file. What has happened is, there's a writ petition that's pending before this Honorable Court, WPC number 205 of 2024. In this writ petition, the limited case of the petitioners are, they are working as lady supervisors, and the promotional post is that of CDPOs, Child Development and Protection Officer. Now, in that, a counter affidavit has been filed by the state, where they say, they have amended the rules and it is, pending notification and approval by the governor. That your lordships, if I may just take your lordships to the writ petition, that in the writ petition, there's a specific averment to that effect. Where's the counter affidavit?
Yes.
I'll just take your lordships to the counter affidavit, I'm sorry, the counter affidavit is annexed to the miscellaneous application. I flagged it, no? Well, it's page 53.
Yes.
Here, my lords have it. Paragraph 13, my lords, last paragraph, that with regard to the statements made in paragraph 10, 11, 12, 13 and 14 of the writ petition, the answer to dependent states that the case of the petitioners will be considered once the amended service rules of the Social Welfare Department gets the assent of the Governor of the State of Meghalaya. So it's not really an adversarial litigation, my lords, insofar as till this stage. Now what has happened is, my lords, that there were 9 vacant posts which would otherwise be eligible, my lords, for promotion, as and when, my lords, the notification comes. Now, these posts have been advertised for filling up by direct recruitment. That is why we are here before your lordships, my lords.
Where's the advertisement?
My lords, the advertisement your lordships would find at page 63, my lords. It starts from page 61.
The general advertisement.
My lords.
Lordship, may kindly pass over the file is not there, my lord. At the end, your lordship may take up this matter. So that in that.
Yes, you can come. You can obtain instructions also.
Yeah.
22.
This is that matter regarding Electricity Regulatory Commission.
Yes.
Here, my lords, a challenge had been raised as regards the maintainability of this writ petition, and on the last occasion, my lords, a submission had been made.
Yes, I had pointed out that the final order has been passed by the commissioner.
Yes.
And therefore,
Two aspects, my lords. I think my learned friend has already addressed your lordships, my lords.
No, we have not.
No.
Yes, please start, yes. Let him finish, yes. Make it brief.
If my friends want to raise the issue of maintainability, my lords, they'll have to begin, I can respond. Or if your lordships want me to place the case on merits, my lords, I can place it on merits before lordships. What has happened here essentially, my lords, without even opening the file, what we can do, a very small gist of the matter. Well, it's the MSARC passed an order sometime in June 2024 fixing the tariff, my lords, for this particular financial year, that is 2024-2025.
Yes.
Now, that a challenge to that, my lords, was made before this honorable court by MEPDCL.
Yes.
Now, we, my lords, were intervening in the matter. Then, my lords, they sought liberty from this honorable court to take their challenge back to the MSARC.
Right.
Now, that matter came to be closed at that. Subsequently, my lords, MSARC heard us. We also came before this honorable court, my lords, with another writ petition. Your lordships said that whatever relief you claim, you go before MSARC, you file your appropriate applications over there, MSARC will hear you and pass appropriate orders. Now, they filed an application, my lords, MECL filed an application seeking recall of the earlier order. Now, we pointed out to the MSARC, my lords, that the power of recall, since it is, my lords, a statutory body, and your lordships are aware of the law on this, that a statutory body has to function within the four corners of the statute. In other words, my lords, if some power is not vested upon the authority, that power, it does not have any inherent powers. In other words, my lords, it would not have any inherent powers. It would have to only function within the statutory four corners of the statute. And that power was not available with the MSARC to recall that order. The primary ground on which, my lords, that entire recall application had been filed and a challenge had been made before this honorable court in the first instance was that they say that the order was passed by one member, even though the matter was heard by two members, the chairman had retired, and the order was signed by one member. And, my lords, they had placed reliance on an order passed by APTEL, a very recent order of 2023, where this issue was discussed and it was decided that one member cannot pass the order. We went back to MSARC, my lords, and we pointed out that way back, I'll just give the date of the order, my lords, the OA 1. My lords, this was in 2011, a full bench, meaning 3 judges of the APTEL, my lords, had already decided this issue that it is competent for one member to sign and pass an order. Irrespective of the fact that whoever heard the order, my lords, one member was very much competent to pass the order. So the judgment that they were referring to, my lords, of General Steel was per incorium. That's one aspect of the matter. That's on merits. The larger issue, my lords, which we had raised before the tribunal, before the authority was, that we said, my lords, that you do not have the jurisdiction to entertain an application of recall. That power is not available with you.
Yes.
Now, that, my lords, has been negated by the commission. Commission says, I have the power and I'm passing the order. Against that, this challenge is there before your lordships. Now, what my learned friend is trying to submit before your lordships.
Now it becomes a different complexion is taken.
Absolutely.
Because now, if he is challenging the order on the ground of no jurisdiction, then he has to go to APTEL.
No, my lords.
Why not?
APTEL will be only, my lords, when it is a tariff order. If it is a tariff order, my lords, my remedy under the Act would be going to APTEL. If it is a question of jurisdiction, my lords, and they say, my lords, the jurisdiction is assumed from the orders that flow from this honorable court, relegating the parties to the commission.
Yes.
Now, once that issue, my lords, whether a certain tribunal has jurisdiction or does not have jurisdiction, APTEL cannot decide it, my lords. It is only a constitutional court which will have to decide, which is a pure question of law.
And the full bench decided that one member is competent to
That is
decide.
on the merits of the matter.
Exactly. So
I am
that
not on the merits. Your lordships may forget the merits. For once, my lords, let us forget the merits.
Okay.
We will have to, my lords, first see whether a forum has the authority or not. That power has to be decided by this court. APTEL will not have jurisdiction to decide, my lords, whether a court has power, whether the statute provides you with that, clothes you with that power or not. That would have to be decided by a constitutional court. So what my learned friend is saying, my lords, that after your order was recalled, another order has been passed fixing tariff. And if you are aggrieved by the tariff, you go and file an appeal before the APTEL, my lords. That, in my humble submission, will have no consequence because it is purely a question of jurisdiction. So once a jurisdiction is an issue, my lords, your lordships would have to decide and answer whether...
That means you seek to sustain the earlier order passed by a single member.
I am saying, my lords, that
even like irrespective of the matter being sent back there, that it was inconsequential because they couldn't have, passed a fresh order.
your lordships have, my lords, have not remanded the matter.
Where is
My lords, I'll take your lordships to the order. Your lordships were careful that at that point of time, your lordships have not remanded the matter. Your lordships have allowed them to withdraw the matter and go back before MSCRC.
I think it needs a detailed hearing.
It will need a detailed hearing.
If that's your ground.
But that is my case. And I'll buttress it with the law, my lords.
What, my lord, one thing is that under the Electricity Act, BIA has no locus to file this case also, my lord. BIA is not...
Who's appearing for the MSERC?
Mr.
I'd like to appear for the commission, my lord. If I could just explain, my lord, why I said there is a preliminary objection on maintainability in the facts of our case.
Where's the
There
order
are,
of
my
this
lords,
court?
first of all, your lordships may kindly look at section 111 of the Electricity Act. My lord. If your lordships may have that in front of you, my lords, it will become very clear. If my lords looks at 111, my lords.
One second.
Yes.
Yes.
Yes, my lord. That's the appellate power.
Appellate power.
Yes.
Kindly see, my lord, it's part 11. This is where the appellate tribunal of electricity was formulated. And please see para 111.
Yes.
Any person aggrieved by an order made by an adjudicating officer under this act or an order made by appropriate commission under this act may prefer an appeal to the appellate tribunal for electricity. So, my lord, first and foremost, all orders which are passed by a regulatory commission are subject to challenge as first appeal on facts and law both before the appellate tribunal. Therefore, it is not that only jurisdiction has been conferred by the parliament to the tribunal on tariff orders. In fact, tariff order is not even a defined concept on the Electricity Act. Tariff is defined, but tariff orders per se. That's one first. If my esteemed senior would permit me just 5 minutes to make my point.
Yes.
The other order.
So therefore, my lord, first and foremost, to say that there are
MECL's
certain
order.
kinds of orders passed by a regulatory commission which should be challenged before a court of record,
20.
before your lordship's honorable High Court, and some have to go to the tribunal, would be a misnomer because the parliament, by framing the act, has made no distinction. That's the first point. Second, my lord, the reason why I say, my lord, and I said that in the last occasion as well, is that the writ, my lord, first of all, there was an alternative remedy, the preliminary. There is now a judgment passed by the Honorable Supreme Court, my lord, as late as 2024, which says that when the matters concerning electricity, the court should be reluctant in obtaining writ petition. That's on merits. Again, that's on alternative remedy. Now, my lord, why I say in this case there seems to be now, my lord, the writ has become infructuous, is for the simple reason that the order which has been stayed in this present writ petition before your lordship is an order which was an interim order by which the commission had reopened the tariff proceedings. This order per se does not fix the tariff. This order per se does not
Exactly.
what should be tabled by the BIA or its customers. It doesn't say. This proceedings has finally culminated into a tariff order which governs the current financial year in question, 24-25, which came to be passed in August of 2024. Therefore,
You're the judgment
my respectful commission would be that alternative remedy lies with, there's an alternative remedy available to them, that is for them to now
The one I gave you yesterday.
how they are making out a case under Whirlpool and challenging a lack of jurisdiction. But more importantly, the fact that there is a tariff order which governs the year in question, which is what somebody could theoretically be aggrieved by. But I'm not siding with the state discom or the consumers. My respectful submission is either one of them, if they have any grievance on that order, the remedy of 111 is available to them, or if at all they want to challenge it, they can also assail it in a petition.
Just one line to answer this.
Your Lordship.
Let me finish. You finished?
Yes. So, yes. No, Lord, just one more point.
Yes.
Last, my Lord's thought is this: that the present writ petition, my Lord, your Lordships will entertain a writ petition when there is a violation of a fundamental right, my Lords. That's a sine qua non for your Lordships to exercise jurisdiction under 226. This order does not affect anybody's rights. That's my respectful submission. Because the order was simply recalled. There was no direction issued here. So even the Lord, if your Lordships were to look at it from a locus perspective to maintain a 226 challenge before the Honourable High Court, my respectful submission would be that this is not a case where, my Lord, that threshold is crossed. And last point on preliminary or maintainability is that my friend, my Lords, from the petitioner side seems to suggest that the Commission lacks jurisdiction in the matter, and therefore the order seems to be, the order passed herein would fall under the exception carved out by the Honourable Supreme Court in Whirlpool, and therefore this writ petition is maintainable. Now, my Lords, in my respectful and humble submission, the Commission is the sole custodian of fixation of tariff in the state of Meghalaya. Therefore, it can't be a case of lack of jurisdiction. It can at best be a case of excessive power of wrongful exercise of jurisdiction, and those orders are also appealable under the statutory scheme. They do not fall under the exception carved out by Whirlpool. I can place that law.
I have not even placed Whirlpool as yet, Millet.
We are reading preliminary.
Therefore, on all four levels, I respectfully submit. Of course, if my friend wants to argue, I have no problem. We are here to assist your Lordship. I leave it to my Lord.
Millet, I am only submitting.
One line to supplement.
Okay,
one line to supplement, my Lord. The identical issue arose before this Honourable Court, my Lord, where my friend said that there is the orders.
That is on a very absolute.
He will not
my lords have passed an order. What is happening is,
I can say Mr. Paul will kindly see your Lordship division bench order. Division bench order of this Honourable Court, my Lord. Division bench.
Which they challenged before the Supreme Court.
I'm showing that Supreme Court also. I'm showing your Lordship kindly see division bench order. Division bench order of this Honourable Court in my counter affidavit, page 80. Page 80. Yeah, you don't know. Page 80. Page 80. My friend starts jumping. Page 80.
Flip-flops of the state is amazing.
Question of law is law.
Law is law, my lords, only when I am on the respondent side.
Is directed against, your Lordship kindly see page 80, the division bench order. The writ petition is directed against the order of December 6, 2022 passed by Meghalaya State Electricity Regulatory Commission at an interim stage of proceeding instituted before it by private respondent herein. There is no dispute that order impugned is amenable to an appeal under section 111 of the Electricity Act 2023. However, petitioner power company submit that alternative remedy is neither efficacious nor appropriate in the present case, since the primary prayer of the petition before the state is contrary to finding rendered by the order passed by this court. Ordinarily, when efficacious alternative remedy is available, the writ court exercises a degree of self-restraint before entertaining petition under 226 of the Constitution filed without availing the regular statutory remedy. Exceptional situation in which alternative remedy is disregarded and the writ petition received may be when the order impugned is found to be in breach of principle of natural justice or wholly without jurisdiction or absurd to the meanest mind. In the present case, the writ petition claims, since the private respondent herein had earlier opposed the court, the objection now raised, the writ petition should not entertain the present petition, would not lie in their mouth. However, such contention is unacceptable. It is possible that in view of the order dated September 5, 2022, passed by this court, there may be any merit in the petition filed by private respondent before commission. However, such an argument may be carried out in appeal merely because petition has been entertained or an interim order has been passed does not amount that to the commission having acted without jurisdiction of the kind that would excite the court to receive the petition without the alternative being exhausted. Merit of the matter have not gone into. Petitioner is permitted to avail the alternative. And I challenge this before the Honourable Supreme Court, page 83.
Supreme Court rejected it.
Am I rejected? Also, I am going to say.
Yes. My friend, may I just respond?
I am not, Your Lordship, so liberty to withdraw and alternative. So the submission, my lord, I am making is that what they are saying is that under 111 they have no remedy is absolutely without any basis. It's complete completely misconceived. And one more preliminary objection I have, my lord. Who are they, your lordship? Kindly see my the counter. They are not consumer within the meaning of Electricity Act.
I am the Millard's Association
Yeah,
of Industry.
Your lordship, kindly
Whom
see.
you think appropriate to hear at the time of passing the interim order?
I am MEPDCL because the question
You
is
make me a party.
And the question is
You make me a party before
your
the
lordship, kindly see
commission.
page 7. My friend will keep on interrupting, I know. Paragraph 7, my lord. Paragraph 7, because everything, whatever pinches...
like my old senior used to say, so an argument have more light than sound. Shed more light than sound.
The age of stereophonic sound.
So, my lord, ultimately, my lord, this matter will require detailed hearing, my lord. Your lord, Mr. Paul.
That's what just two things I wanted to say.
No,
lordships are right. Just two things what my friends have
objection also have not highlighted, but it will take half an hour.
In these issues, that writ petition, as my friend was appearing, I was appearing also. Question of jurisdiction is not there. Here, there is a pure question of jurisdiction. Jurisdiction, I cannot take it in appeal under 111.
All questions, all you can take.
Point which there's the only point you might have some,
because the commission interestingly does not answer that. That whether I have jurisdiction.
My lord, detail 100 pages judgment, all judgments.
I think the commission is.
My friend has not.
My commission is appropriately represented.
Not the premier objections raised by the respondents with regard to the. Yes, Mr. Wills. Heard the primary objections raised by the respondents with regard to maintainability of the initial petition. As the matter deserves further examination, it is the same after vacations for hearing.
In third week, my lord, first 2 weeks are very tight. There are so many hearings.
But
interesting, very interesting.
We'll have to satisfy your lordship.
This court could dispose of today itself.
But this would take a little bit of time.
Daily list item number 1.
Yes.
Please, Lordship.
You're appearing? Who's appearing?
Yeah, I'm appearing, my lord. I have just now received the instruction also, my lord. Kindly give me some time, my lord, to go through the instruction and.
Then RP General Center appears on behalf of the sole is the of the respondents. No. Yes. Such service complete is the matter of revocations on so and so. It is matter on so and so for affidavit.
And a copy of contempt petition can be responded.
Item number 2.
Yes.
Or we file affidavit to application for vacating.
Vacating?
They file an application for vacating the interim order.
Affidavit for vacating or application?
Application for vacating. We filed a reply.
Have you filed your objection?
My lord, we filed today. My lord. We served a copy.
Where's the objection? You've given copies?
Yes, you received.
My lord, I appeared for the immediate respondent. I also filed an application for vacating.
That was served yesterday evening.
My lord, 5 electors I am representing. They have withdrawn their support. No, my lord, there is a stay order. My lord, my only contention as per the law, my lord, is very clear. Once the chief loses the confidence, my lord, he cannot continue in the office.
Let us hear the first application first.
Yes, Mr.
Because that application is not even listed. It was given to only yesterday evening.
My application is listed today, Archip. I have.
Application is done with double. Miss case number
218. Miss case 218, Archip.
This is a new miss case filed by.
Filed by us.
222.
222.
Okay.
To that we will file a reply, madam. That was given.
222 also. Or 218.
That was given to us yesterday evening, madam. It was filed yesterday, it seems.
So we take up 218 first.
218.
218 first.
Yes.
Archip, may I please, Archip? In this miss case 218, this is an application to vacate the order passed dated 6 December 2024 in the writ petition 452 of 2024, thereby allowing the petitioner to function as a Sadar of Nongpor. So, Lordship,
what are your grounds for
the grounds? Yes, exactly.
The order?
Exactly. They have replied to it. Mainly,
what are your grounds?
Yes, my ground is that we have followed due process under the mandate of Section 6 where they were given an opportunity. Just a background, Lordship. The petitioner was reinstated in the month of March 2024. Now,
that's the only consideration why this court passed interim orders.
Yes.
Otherwise, Mr. Mappan, we don't.
I'm coming to
don't,
that.
We don't interfere with
Exactly.
suspension.
Exactly.
But the thing is that if you reinstated a person in March only, and on the same grounds you have suspended him again.
No, not the same ground. I'll point it out.
Exactly same ground.
I'll point it out.
Sit down.
Let me just show. I'll point it
that right in the beginning of the application.
Yes.
Now, there was a complaint in the same month itself, in the month of March. A few days after he was reinstated, there was a complaint filed, and we did not suspend the petitioner immediately. We have given an opportunity to show cause. Now, the petitioner had seeked time twice. It's there in the red petition on medical ground. Now, finally, in the month of September, the petitioner appeared, and the complainant had also appeared. They were given a chance to be heard. After they were heard, they were allowed to file their written argument and show cause. That written argument was filed by the complainant in the month of September. The petitioner filed in the month of October. It took us 2 months to decide this matter, and finally, in the month of December, we found that the complaint was genuine. And after that, we had passed the order on the 2nd of December to suspend, and thereby a notification on the 3rd, the following day. So the grounds which were there in the first complaint, let's come to page 33 of the red petition. There were 2 grounds on the first complaint. Page 33. That is the order of the first suspension.
Yes. Page 33.
Yes, Arch. These are 2 grounds, Arch. May I read, Arch? That Shri Wanprang CM Nongshai, which is the petitioner, Sadar Ilaka Nongpo, had tried to change the Nongpo Ilaka Sadarship to a CMship without the consent and understanding of the Lungdo and the Longsan Mansan of the Ilaka. That's the first ground. The second ground was that Shri Wanprang CM Nongshai, Sadar Nongpo Ilaka, had failed to work together with the Rai. Since his appointment as a Sadar, he had failed to convene meetings of the Nong Sansha Rai. He had failed to provide the annual expenditure of the Ilaka. He had done away with the customary practice by appointing the headman outside the Ilaka without the knowledge of the Lingda Rai. These are 2 grounds.
Yes.
Now, can you see this
is the first order, 11 April 2023.
Yes, this is the first. He was reinstated
on April 2023, right?
Reinstated on 4th March 2024.
What considerations? Okay, these 2 grounds, fine.
So now the grounds on the present complaint.
No. Now reinstatement order, where is it?
Reinstated order is at it's order dated 4th April or March 2024. That is at page 57. 57. That is based on an inquiry of 14 December 23. Now, yes. the present complaint. 57. In the present complaint,
so the court is substantiated. That means it is honoriated.
Yes.
Right?
So these are the grounds on the first complaint.
57, now, these 2 grounds only.
Yes, these 2 grounds.
Yes.
Now in the present complaint, can you come to my, it's enclosed in their affidavit also, it's also enclosed in this petition also, in this miscase. Can you see miscase 218 also?
No, where's the complaint in the present one, in the petition? In the petition, where's the present complaint? It's not annexed.
In the present complaint is annexed. That is at page 63. Okay. That is the first complaint that is filed on dated 13 March 2024, page 63. Okay. Annexure 13.
This is by whom?
This is by the Longsan Mansan.
This is by Mr. Sen and party. Okay. This is the 13 March 2024. This is for reinitiation of inquiry.
Yes. And after that, the next page 67.
Revival of the old inquiry.
That's what it says. That's what it says. Then there was a reminder, page 67, to this complaint. 67. That is 13.
This won't hold good. Yes.
There's a reminder to that complaint. It's page 67 of the writ.
Yes.
Now, after that, there's another complaint. That is
So,
page 69.
reinitiation of complaints.
Yes,
Of
reinitiation.
inquiry, Mr. Marpan,
There's another complaint.
will amount to double jeopardy. If he's
No,
already been
if you go by
exonerated,
this complaint only, then it looks like they are asking to recall or to reinitiate that. But if you look at the complaint at page 69, Your Lordship.
Yes.
69. This is not a reminder, this is not reinitiation. This is again, looks like a fresh complaint. Page 69.
Yes.
Now, from this three...
Where are the pointed charges?
Now, this has been taken under observation in the order of suspension. That is...
No. See, you're saying that you have to show the court that this present suspension is nowhere connected with the early charges in the early suspension.
No.
If you can satisfy the court that yes,
the observation
charges, that is, he wanted to change it to CMship and appointment of a headman outside the local area. If you want to show the court that this present suspension is, that means he's been exonerated from other charge because inquiry was held. Due inquiry by a judicial officer who found that there was no substance in the complaints and the complainants could not substantiate allegations, right? And so exonerated the district council, then you only reinstated him in view of the inquiry report given by the inquiry officer.
Exactly.
Now, after the reinstatation, being reinstated, another complaint came for reinitiation of the inquiry. Now, inquiry is over.
Yes.
Right. Yes. Why did she have sought other relief? How can it seek from the same forum? And then you see at the 69 is a complaint. It just says act of misconduct, wrongful act. I can say anything. I don't like your face. I'll say you rightful wrongful act. See, show the court where the fresh charges have been put up by whoever is concerned, showing the lack of confidence, in view of these acts, and so the district council, acting as a adjudicatory body, has examined the matter and suspended him again. If you can't satisfy that, then the interim order will continue.
Can you come to the order of
Let
suspension?
the matter be heard. Yes.
Can you come to the order of suspension? Page 8 of my miscase.
These are the only complaint. That's the only complaint.
These are the complaints. There are other complaints also.
There are other complaints.
Other complaints.
No. I mean, where is that?
It's in their miscase.
No.
And that is,
One
that is
second.
the relevant consideration.
The most important party here is the district council. They have to place the materials to show that which the complaint they have received, on which acted upon. That's all. Now, where you please wait. Yes.
Now, can you come to page 8 of my miscase?
Okay. Yes.
After these two complaints, one is reinitiation, then there was a reminder, and after that there was a fresh complaint, page 69. Now, in the order of suspension, can you see, there were two other complaint written argument filed. That is 27 September 2024 and 4th October 2024. In this two complaint, which again the complainant would be in a position to better explain. These two complaints.
Where's the complaints in your miscase? Those complaints?
This complaint are included in their miscase. They haven't in their miscase. From this three,
doesn't even have a copy of that.
This 27 September and 4th October 2024, and also the written argument filed by the petitioner, that is 3rd October 2024. From this three written submission submitted by the complainant and the writ petition, these three observations were made. The first one, Your Lordship, is regarding the reinstatement. However, I may be allowed to read. There's three observations with me. The first observation was that Shri Wanprang C.M. Nongshai was reinstated as Sardar of Nongpo by notification dated so and so. However, it has become evident from numerous petitions and representation by the Lungda Raj electors and Longsan Mansan of the Nongpa Sadaship that the Sardar had failed to gain confidence of the elector. That is the first observation. Second observation, the lack of confidence has created a deadlock in the administration in the Nongpo Sadaship, thereby impeding the smooth functioning and affecting the interests of Ilaka and its people. Third observation, in the interest of the administrative justice to ensure the continuity of the governance and to address other grievances of the elector, it is imperative to conduct a fresh and thorough into the matter while also taking necessary interim measure to prevent further administrative disruption. These are three observations, which is completely different from the first complaint. So for that reason, this is a preventive measure. The notification that they are challenging the 3rd December 2024, and the order of suspension is just an interim measure taken by the District Council to ensure that there is a fair inquiry, there is a fair investigation in the matter. And Lordship Direct, we can expeditiously take the inquiry. We had fairly done that the earlier.
Well, I already have predetermined, because even here this order of suspending him again is just on lack of confidence.
That we have to investigate the matter. This is pending inquiry. The suspension is pending inquiry. We need to do our job.
Now, what did you accept the inquiry report of the inquiry officer then?
Sorry?
What did you accept the inquiry report? You are the authority.
Yes, we have accepted. That is on the previous charges.
And ask for fresh inquiry or frame your own charges and take up the matter. Nothing stops you from doing that.
No, but again, if he's allowed to continue.
The only hurdle you have is that you have reinstated him, and the charges that have been brought again later on, nowhere specific about anything. It's just the first one is that misconduct or wrongful acts.
No, the first charges are very specific. With regarding to, I have already read, those are completely different.
Yes, Mr. Sen, where's your complaint? This is.
Now, Your Lordship, before that, my Lord, if I can again take Your Lordship to that 2nd December, the opening paragraph is it's a case of no confidence, Your Lordship.
2nd December meaning?
2nd December, just now my learned friend has referred to. 2nd December passed by the District Council.
So let's see a miscase.
My Lord, miscase at page 29, Your Lordship, this order is there. My miscase 222.
Page 29.
Page 29.
Yes.
Lordship, only the opening paragraph I read, dated 2nd December 24.
I will see the complaints.
I'll just come to complaint before that, my Lord. The matter came up for consideration before the Executive Committee in response to the petition filed by Windows Right electors, Snang and Matsar, the Nongpo Siddharship against Sri such and such Siddhar of Nongpo Siddharship, alleging the Sardar had lost confidence. They have referred to us, lost confidence of electors and was unable. So this was the contentious issue before the Executive Council. Now, what was my complaint? In 2nd paragraph, they have referred to our complaint dated 27 September 24. Now, I have annexed this.
Let's see that.
I have annexed this, my Lord.
You didn't receive copy complaint and annex it.
They have not given a copy, my Lord.
I have given a copy, my Lord.
So,
I have served a copy.
324 days. Wait, which page is it?
This is at page 19, Your Lordship.
Okay.
If I can just read it, my Lord, dated 27 September 24. The objection against respected sir, in connection with the above cited subject and also in connection with your instruction after hearing dated 24 September 24, we 5 Lindos of 5 rates such and such, my Lord, some 5 rates have come forward to put written argument on our opposition to C. Wangpan say because of his negligence has caused division within these rates, especially in relation to the people, the children at large under the Elaka immediately after his reinstatement, as Siddhar of the Elaka, and on his other action as follows below, my Lord. Now we have specified what are those allegations. On 26th April, much after his reinstatement, my Lord, such and such has appointed a new Lindo under the rights as reflected in social media, and also there is a request to lodge a complaint against Session Lindo, who is the current Lindo, right, so that a new Lindo will be appointed under his jurisdiction. 2. On 21st September 24, C. Nongchai went back to Right Sakwai to form a union of village headmen under the Right Sakwai to dissolve the entire Right Sakwai. 3. Under the Right Nongpo, Sri Nongchai after reinstatement continues to disrespect the Lindos, whereby he worked forcibly under the raid without his consent. A Siddhar's judgment on land Trinitya Makri, which is located in the village of Pamsiam, he further emphasized and decided without proper examining the writing of the village and right, this action is forceful and insensitive towards the village Darbar and the right. The Sardar judgment on the land Telia Thaba, which is located.
Now you reply to all these in the complaint.
All these complaints are there. What is most important here, my lord, we have expressed our total loss of confidence. There were 6 electors, 5 have lost. Now, this was duly taken into consideration in that impugn order of 2nd December, loss of confidence. Now, my lord, I come back to the Act. What the Act say, my lord? Section 6 and Section 19. Section 6 clause, my lord. Section 6 clause, your lordship. Just find it. Clause 7, my lord. It clearly say, my lord, if he loses the confidence of the electors, then he has to be placed under suspension, my lord. And this is not a punitive suspension. Pending resolution of the deadlock.
Who's the electors?
Well, there are 5 lindos, 6 lindos, my lord. Out of these 6, my lord, the 5 lindos we have withdrawn the support.
No, who are the electors? Only 6 electors. It's long.
6.
No, that includes Longsan, Mansan, and
Longsan, Mansan.
What's the entire electoral college? How many people constitute entire electoral college?
That numbers.
Whether loss of confidence by.
My lord, the Darbar constitutes of 12 members, my lord.
12 members.
12 members. 3 are Mintris, my lord. 7 are Lingdo Right and 2 Longsan Mansan.
So the Longsan Mansan, they have lost confidence in you.
Yes, they have. This is a complaint. 5 lindos per Langsang Mansang.
My lord, even otherwise, out of 12, only 5 are with them. So 7 are with us.
Now, my lord, 6. Removal and suspension of chiefs. 6 clause, my lord. Clause I.
Yes.
He has lost confidence of majority of his electors or the people of the Alaga.
Majority, that's the thing.
So, my lord,
that's why I'm asking. I was asking. He has lost the confidence of 6I. Majority of his electors.
No, lordship will
now,
see.
That's why it's called asking whether you constitute the majority of the electors.
No, lordship. Even if you lordship will see, my lord.
How many electors are there?
Numbers you don't have, but.
What numbers? The numbers should be there. Lots of confidence that should be. If there's a very basis of the suspension,
exactly.
Then you should know that there are how many electors, 5, how many have come, how many Longsans, how many Lindors.
My lord, in fact, this complaint was signed by Longsang Mansang also, your lordship. Lordship will kindly come to page 23A, my lord. Their signature is there.
We can't. We have to be sure. Otherwise, 23A.
Yes, 23A.
Of your miscase.
Yes.
23A.
Yes, my lord.
Okay.
I, the Lindo, along with the Lindo's assistants and right now, we hereby approve the writings prepared by the 5 rates to forward to the KHSC Shillong over the objection against the CM and the Sildar of the Alaga. So, my lord, these are the others, all others, my lords. They are also signatories to it. They have also approved it. And all these things were before the district council.
Are these electors? Pator also?
No. Not all of them. Not all of them.
Doloi Raj?
Not all of them.
The problem is the last day today.
My lord. Well, my humble submission, my lord, what I am saying, your lordship.
No,
sure,
this is. The thing is that court not interfere in suspension. Lordship. Unless the court is sure that, the suspension is on bona fide. Because only the question is that he's been reinstated.
Lordship.
Charges were made, inquiry gone into, couldn't be substantiated, then he reinstated.
No,
now the thing is that if it is a fresh suspension, there can be no interim order. He'll face the inquiry. If he faces the inquiry conducted by judicial officer, and then judicial officer is given inquiry report accepted by the district council. Now again, fresh complaints, loss of confidence, so on and so forth. Maybe they are substantial charges.
My lord, this is a case of loss of confidence, my lord. And if there is a loss of confidence, now what is happening? This is all temporary measures. Now only the
the majority of the
majority of lordship will see, my lord. This is signed by all the rights, my lord. All the Langsang, Mansang, all has signed it. Lordship can kindly come to page 24 onwards. Who supported this?
Longsan.
All the 5 rights, my lord. All the 5 signatories of all the 5 rights back this complaint. So my humble submission, what is my humble submission? This is, my lord. Now administration will be looked after by the district council. Now your lordship will appreciate, my lord. Chief without Darbar, he cannot function. My lord, once the deadlock is resolved or otherwise, he comes back.
How's the confirmation inquiry?
Give us a direction, expeditiously we will.
Within 1 month?
At least 2 months.
My lord, only few things I wanted to point out, my lord.
There is an administrative officer which is there.
I'll answer also.
Going to take charge.
Page 41, if lordship kindly comes, my lord.
Of your affidavit?
Of the writ petition, my lord.
Page 41.
Page 41, my lord.
Yes.
But these were the charges framed against the petitioner, my lord, by the inquiry officer. Now, last charge, he has lost the confidence of so and so, Sinjuk Nong Sensa, right of Nongpo, Sardarsip, as well as the court CM Nongshai Pillow. Now, even this aspect was examined at that point of time, my lord. Inquiry officer absolves the petitioner of all charges. District Council accepted that, my lord. And now, Lordship will kindly see what is the so-called notice issued to us, my lord. Lordship kindly comes to.
One thing, Dr. Mojika, is that where the proceedings of inquiry, where's the inquiry report?
Never given to us, my lord.
Given by the judicial officer.
Let them place it in affidavit, my lord. The matter may be taken up in the month of
I
January.
will appreciate one thing, my lord.
This
This is not a punitive suspension, my lord. This is, my lord, pending, my lord, resolution of the deadlock.
Question of the entire process has been gone into. Now, if the only case is a case of double jeopardy, okay, double jeopardy in the sense that they have already been tried for these charges, for which they've been exonerated, and then on the basis of that thing they've been reinstated. Now they have come again with this, their case of same charges. Loss conference already taken up in the inquiry.
No.
Again, a suspension.
27 September, all the incident we narrated, my lord, March after his reinstatement.
Let's see the inquiry report. You produce it.
Well, the inquiry, I don't know whether it has been conducted. Pending, my lord, the deadlock.
Take down in the course of hearing. In the course of hearing, Miss Case 20, these two minister applications are taken together. Which is date to these two applications are taken together, which have been filed for modification, alteration, and vacation of the interim order dated 6/12/2024, passed by this court in the main writ petition. In the main writ petition, stop. On hearing the counsels for the parties, Mr. S. Marpan, appearing to his counsel applicants, has submitted that the suspension of the writ petitioner was occasioned in view of fresh complaints which had been received, and the suspension order was passed, and received, which also to receive on the loss of confidence. And apart from other charges. Stop. It is submitted that, notwithstanding the fact that an earlier inquiry had been gone into and the petitioner reinstated after due inquiry, the fresh charges that have been brought forward demand that a proper inquiry be gone into, and as such, the interim order be altered to that effect to allow the officer to function, and the petition be placed on suspension. Stop. Mr. S.N., learned counsel for the applicants in Miss Case 222 of so-and-so, has submitted that the loss of confidence is apparent by the complaint itself, wherein a majority of the electors have appended a signature to the complaint, and as such, as per section 6 of the Act of 1959, same Act, for subsection of Chief Headman Act 1959, the ground of suspension is valid and deserves and is not liable to be interfered with by this court. Next one, per contra, Mr. Dr. N. Mojika, appearing for petitioner, has maintained the stand that the second suspension which has been inflicted upon the writ petitioner is on the same charges on which a due inquiry was conducted, and he exonerated and reinstated in the month of April 2024. The Senior Counsel also referred to the statement of charges of the inquiry to show that there are one and the same, for which the petitioner sought to be suspended again. Stop. This court has considered has noted submissions of the parties, and also observes that though courts do not normally interfere with suspension orders, in instant case, as it appears, in instant case, the interim order had been passed in view of the fact that the allegation was that the second suspension was on the same charges. Notwithstanding this circumstance, in the course of hearing, it is found that the inquiry report, the early inquiry report, which had been submitted to the Respondents' Council, as also other details as to the exact number of electors and the designation, so as to determine the loss of confidence, is not available for the court.
Lordship, allowed to interject, Lordship. It's reflected in the order of suspension, the order of reinstatement regarding the inquiry. Just one line by the
reflected. I want an inquiry report of which is the officer. So in this situation, it is this court not able to go forward to pass any effective orders, only to direct the respondents to place on record the inquiry gone to by the judicial officer, as also the exact number of electors to the office of the what's that? This is the Sardar of Longpur. Yes. This on so and so for further consideration.
The interim order will continue.
Interim orders will continue. Unless you satisfy. Notwithstanding anything, this.
Item number 3.
Deeply.
This order isn't there. Rest of the matters are 215.
Daily list, item number 3.
May it please your lordships. Lordships, I'm praying for some more time to file a rejoinder affidavit, lordship.
One put in sickly.
Lordships.
Lordship, here the matter has become infructuous because he has already applied for provisional as a provision. He has already applied for selection for the coaching instructor. In my
boxer?
affidavit as a boxer.
Lordship.
Yes. As a
Lordship,
boxer.
if I may be allowed to just file my rejoinder.
MS A.D. Cruz, please be allowed to obtain instructions on the submissions of MS P. Bhattacharjee for respondents number.
Respondent number 3. 3 and 4.
3 and 4. That the writ petition has become infructuous. Yes, this certification.
Obliged, lordships.
Item number 4.
I'm appealing for respondent number 4, my lord. I'm praying for some more time, my lord.
Lordship, we are supposed to file a rejoinder affidavit to the counter affidavit.
Yeah, Dr. Muzika for respondent number 4. Place was allowed further 2 weeks time to file affidavits. Petition also permitted to file the joinder. Allowed further time for the joinder. The affidavit files 1, 1 and 2. Yes, also yes.
Obliged, lordship.
Item number 5.
Mr. Sen, where's the affidavit? Already been paid, everything.
80%.
Then? What? Why
Remaining
20%?
person, my lord, there was some kind of inquiry, your lordship. I need to place an affidavit. Some irregularities.
Mr. S. and one in C pays funds allowed further 2 weeks time to file affidavit. Is that after and so on?
Item number 6.
Lordship, here affidavit in opposition has already been filed on behalf of State Respondent 1 to 3.
1, 2 and 3. What about B. Kharwanlang? 4 and 5. File?
Not yet filed, Lordship. It has not been filed.
B. Kharwanlang 4 and 5 is what? MPSC?
No. State Bank of India.
Huh? State Bank
SBI,
of India.
SBI, yes.
What's the matter about?
Regarding family pension, Lordship.
Acha, where's 4 and 5? Yes, from the table of Mr. K. Paul. Number 4 and 5. Pension matter. No instructions. You only find Mr. E.M. Sangma submits that. Oh no, on behalf of Respondent 1, 2, and 3, the affidavit has been filed. However, on Respondent 4 and 5, there is. When? How much time? Yes, 4 and 5 are allowed for a tweak file application or to file affidavits.
Item 7.
File affidavit.
One and 10 we file affidavit.
1 and 2 to 8 is the respondents. I have left and I'm praying for some more time.
So, 1 and 10 you are
NHIVC.
only for
1 and 2 to 8.
MS ARC only GA for 2 to 8, MS ARC Hasim for 9, oh sorry, GC Marbo for 9 and F Kasim Young for 11. Pray for not 2 weeks further time. Affidavit on behalf of respondent 1 and 10 has since been filed. This applications.
Item number 8.
Yes, also and this application.
Is government yet to file the application?
My lord, this is a pension matter. We are aware, my lord, there is an urgency in pension matters. My lord, we have received instruction, but the instruction seems to be quite unclear. So I'm praying for another opportunity, my lord, to file my counter, my lord.
MS ARC only for 1 to 4 and he pass up pray for not for the 2 week time to file affidavit. Yes, this is the after and so on.
Item number 9.
Please, Lordship, this matter has been settled by the Lokayuta, not Lokayuta, Lok Adalat, Lordship. The last occasion, no, Lok Adalat, my Lord. The last, the department,
Very good.
they have come. From my department, no one department, these people come. These people. The director.
Yes,
Director. Account director.
seen the award at Flag A. Showing the matter has been settled in the last National Lok Adalat held on 14.
Lordship.
14th was also. Only in terms of the award, matter stands closed and disposed of.
Please, Lordship. Authorised, Lordship.
Item number 10.
May it please your Lordship. Lordship, in this matter, we are yet to obtain instructions.
Why is it every time with your case you can't obtain instructions? What's the matter about?
Lordship, the petitioner has been working in as a constable. He has been removed from service, so he's praying for the reinstatement. He's been arrested.
When was that filed? When was the petition filed? October. Yes, sir. So the petition filed October, the learner JA has yet to receive instructions. Yes, list after a list also and so for affidavit positively. Yes.
11.
Similarly, with item
Similarly,
10 and
yes.
10 and 11
You are
are
paying here
connected.
also?
Yes.
Same constable also?
Yes, Lord. 10 and 11 are connected, Your Lordship.
12.
Yeah, please, Your Lordship. Entering appearance for respondent number 4, my Lord. Secretary, my Lord. Yet to file my wakalatnama, my Lord. Just enter appearance, my Lord. May kind after vacation, my Lord.
Yes, Ms. S.K. Son has an appearance on behalf of the respondent number 4.
4.
Such notice is complete stop. EPS was allowed to can file affidavit list on so and so.
My
Lord.
Hello.
Affidavit.
No, Your Lordship.
Hello, bless me.
13. 13.
Please, Your Honor. Your Honor, appearing for respondents 1, 2, and 3, Your Honor, KHDC.
Yes.
Your Honor, we had to receive instructions.
Where's the petitioner? Mr. Changreso. Yes, what
Your Honor, we are yet to receive instructions on this matter, Your Honor.
the contempt?
No, Your Honor. It's changed the order, Your Honor, for the training license, Your Honor. Your Lordship.
MSC Nonclaw is present on behalf of 1, 2, 3. None appears on the petition list on so and so.
Much obliged, Lordships.
14.
Maybe please, Your Lordship, that suspension period.
Yes, my Lord. We have obtained the instruction, my Lord. He was initially placed under suspension, my Lord, by an order dated 8th May. 8th May. 8th May 24, Your Lordships.
Yes.
Now, my Lord, that suspension was reviewed in the month of first week of August 24.
Okay.
First week of August 24, my Lord, and thereafter further extended for another 90 days, my Lord. That is at page 56 by an order dated 5th August 24. Now, in fact, my Lord, that 90 days has expired.
Yes.
But there are serious charges against him. But we had the, no, my Lord, I am coming. We had the intention, my Lord, to review it, but unable to do it because of the, my Lord, prevailing situation in the university. So this is the instruction. This is a fact, my Lord, we could not review, but we have been prevented by certain reasons.
Yes.
So Your Lordship, then he may be reinstated immediately, and so that he is going to retire on 30th
As regarding,
June
my Lord,
25.
as regarding, my Lord, the departmental proceedings, my Lord, charges has been framed. He has filed his statement. That will proceed. That will proceed, my
That will proceed. That departmental inquiry can be counted in 2-3 months' time.
No, my Lord, not at this stage.
Because he is
Your
going
Lord,
to retire by June 30th.
Yes. take down.
And his MCPA can be
those
released,
I do
but
not
that was
have- do not
due,
have instruction.
due in 2017, Your Lordship.
That is incident.
That has to follow.
The petitioner was placed on suspension on 8. He is serving as what?
Executive engineer.
The petitioner who stated to be serving as an assistant, as a
Executive engineer.
engineer. In the respondent, in the respondent university, under the respondent university, was placed on suspension on 8th May 2024, which was thereafter extended for another period of 90 days on 5th 8 2024. Stop. The period of extension, it has been contended by the Legislative Council appearing for the petitioner, has since expired on 4th November 2024, and as such, by efflux of time, and as per the extension order, the petitioner is liable to be reinstated to his post. So further submitted that the writ petitioner is also due to retire on
30th June 2025.
On 30th of June 2025. Stop. Mr. S.N. Leonard, counsel, on behalf of the responding university, has submitted that due to the prevailing situation in the university, though it had been contemplated to extend the suspension of the writ petitioner in view of the nature of allegations, the same could not be effected. He however submits that as the departmental proceedings are going on, the respondent will be allowed to complete the same. Yes, next paragraph. It is seen that the point in issue in the incident petition is short and confined only to the last extension of the suspension order, which is dated 5th August 2024. Stop. A perusal of the same indicates that the respondents, in pursuance to an emergent executive council decision, had held on 5/8/2024, had extended the suspension for another 90 days with effect from 6 August 2024. Stop. As the said period is since over, it therefore naturally follows that the petitioner is entitled to be reinstated, and the same is ordered accordingly. Stop. Next paragraph. Needless to add, the department proceedings which are underway may be concluded expeditiously at the earliest.
At the earliest.
The election stands disposed of. Yes.
Petition can be disposed of. That's
Yeah, disposed of.
Obligement.
And the MPCA,
My lord, there I have no instruction.
that has to follow.
They can hesitate. Obligement.
MACP.
MSC. Modified.
Second call.
Deeply obliged.
Second call supplementary list. Item number 3.
Where the petitioner? None appears to have a petitioner even on second call, which has been made at 2:30 p.m. Matter stand over to after vacations. Yes.
21.
Yes.
My friend, the Advocate General had sought time, and the matter was moved. I had just pointed out, my lords, that the state has the stance of the state on the writ petition is that the matter is under consideration, and they would be given the benefits once, my lords, the rules are
Not going to be reconsidered.
Considered.
once the rules are amended.
Mallets.
Yes.
So, as a matter of fact, my lord, if your lordship will see the writ petition, the existing rules, my lord, provide for recruitment by way of direct recruitment only, my lord. Now, there was some negotiation and discussion between the directorate and the government that the rules be amended and 75% should be by direct recruitment and 25% by promotional. And rule further provided that 20 years of experience in the cadre below will make the person eligible for promotion to the
20 years.
20 years, your lordship, draft rules. There is no, they have also not disputed that part in the rules.
They meet the criteria. Mallets.
So that they 20 years, because there is no promotional post. There was no promotional post for them, my lord. The requirement was, my lord. So now rules have not been amended as of now. The rules provide for direct recruitment. Now, what is under challenge in this miscellaneous application is that the advertisement which has been issued for direct recruitment, my lord. So direct recruitment is still 75% posts are to be filled by direct recruitment, my lord. There is no bar in having direct
Their
recruitment.
anxiety, I think, is because
That they are
all the posts are advertised.
So now they have not placed any material to, only 11 posts have been advertised for direct recruitment, my lord.
The 9 had already been done earlier. The 20 posts, 9 has already gone. Sorry, I'm 17, Mallets.
Because
11
there
have
is
been
no-
advertised now and 8 have already been.
Your lordship, in the entire, if your lordship will see the advertisement, my lord, kindly see the advertisement. Advertisement. That miscellaneous
Page
application.
61 minutes.
Of the miss case.
Mallets.
Miss case. Advertisement, and your lordship will see the advertisement. It is child development post, and then the category wise roster also, your lordship will see that unreserved, Khasi Jaintia, Garo.
At serial number.
Serial
Number 1, my lord.
1, my lord.
CDPO.
Name of okay.
Yes, my lord. And then your lordship will find that this is a 9, total 9 posts are there. And in terms of statutory rules, the posts have been advertised. If they succeed, my lord, your lordship has ample power to direct the government to create supernumerary posts also.
That will only lead to further chaos.
And because they have, as of now, what is their legal right? I put a question to myself, my lord. Their legal right is to the extent of 25% post only, if they say so. Even that rules have not been amended, my lord.
How many prisoners?
Yeah, and that details are also not on record, my lord. I have been trying to find out the cadre strength also. What is the cadre strength?
The last date submissions of this.
And this, your lordship, also this was 27th November.
Online application
27th November, they are coming on the fag end to stall, and those who are waiting for that.
We have been writing to the government. Mallets,
27th November is the advertisement, my lord. 27th November, and they are filing on the pen and last date, that too by mention memo, so that
It's not
we
by
have not.
mention memo, it's on the list.
This is the,
My friend gets
I
a little carried
instructed
on.
my colleague instructed me, and the matter
carried
is listed for hearing on 30th January, my lord. 30th January. And
Well,
if
my
they,
only anxiety is, as I pointed out, Mallets, that if the posts are filled in, then that would lead to further chaos insofar as this issue is concerned.
there will be no chaos. Government has agreed for 25%.
So if the government has agreed for 25%,
government
Mallets,
has
those posts can be left vacant. Rest of the posts can be filled up. That would have no. We would have no grievance then.
How many petitioners are there?
Well, it's total number
20.
77
How many posts will
petitioners.
be up for contention?
I'm sorry, Mallets.
25% of these posts will be how much?
25% would be, Mallets, about 8.
I'm sorry, my lord. They're 61.
So
Oh,
that-
sorry.
so it would come to roughly about 8 posts, Mallets.
How many posts have been advertised?
9.
9.
The 20 out of 20 posts, my lord, 75 posts are, as per, I don't know what is the cadre strength, my lord, that instruction. Out of 20 posts, 75% posts are amended rules. So then still 16 to 17 posts are to be filled by direct recruitment only. Direct recruitment
So
only.
then what would happen is, Mallets, there would be
And-
probably
and-
2 or
and-
3 people
and
that,
therefore-
that would come within that zone of,
And
Mallets,
now-
which posts would now be through
77 of them are
promotion.
here before, my lord.
From the present advertisement, 25% will constitute how many posts? 9?
Well, from 9.
9 are there, and what is being said just now, that total cadre strength is 20. What I
No,
that
no,
is also,
cadre-
there is no averment,
cadre-
nothing, no pleading, my lord. And if your lordship, on mere apprehension, my lord, because this let the process go on, subject to outcome of your lordship's order. Because stalling means, my lord,
No, the thing is that, see,
the
can't
people
have
will
it,
be deprived of.
contingent upon, see, the affidavit that you filed has categorically stated that
My
you are
affidavit-
amending the rules, and then
No, my lord,
as when the rules are amended,
that
then
is
you
the.
will consider the.
I'm really sorry to say, my lord, that what the affidavit says, that directorate has written to the government and for amendment of the rules to the extent of earlier government agreed to the extent of
Where is that letter?
25%
Show me
from
that
promotion. That is only thing which is stated, my lord, in the affidavit. I kindly see the affidavit last
No,
part.
it says para 15.
I'm coming. That's why I was surprised also how we prepare our affidavits also. That's a, yeah, is there in the counter itself.
Where is that?
Now, your lordship will see the last date, paragraph 22. Page 56, my lord, of the miscase only. Whole discussion is going on, my lord, with regard to the ratio. What is going to be the ratio, my lord, between the
Para 26, my lords, it's 50-50. It is not 25.
this is the proposal given, but government has agreed to.
Para 26, if my lords kindly have a look at page 58.
Let me show that.
However, when the directorate felt
We have
to
felt
avoid
it
more
more to avoid
complications,
complications.
However, present directorate felt that to avoid
50-50
more
basis.
complication, so directorate is writing, my lord.
50%
And
by
what is the
direct
stand of the
recruitment.
government, my lord? Government is 25%. And as on today, statutory rules 100% by direct recruitment, my lord. And your lordship kindly see page the statutory rules, my lord, which are there in the counter affidavit. Just see one page, my lord. Kindly see the rules. Page 11, my lord. Page 11 of my counter affidavit. And page 12 at the annexer 1 of my counter affidavit.
Respondent 326.
Yes, my lord. 326, page 12, my lord. And page 12, 7.2, my lord. 7.2. Appointment to any post in grade 2 under sub rule 4 shall be made by direct recruitment. So these rules as on today, which is prevailing, my lord, is direct recruitment. Some negotiations have taken place.
Where are you reading from?
I'm reading from 7.2, my lord, page 12, my lord. Page 12 of the counter affidavit, my lord. Appointment to any post in grade 2 of subclause C under sub rule 1 of rule 4 shall be made by direct recruitment on the result of competitive examination and interview conducted by commission at such interval in accordance with the syllabus, etc. So as on today, statutory rules are there, but what has happened in the meantime, which my friend is relying on, my lord, kindly see, there was some representation and some discussion about the provisions. Page 21, your lordship may kindly come to page 20.
Affidavit.
Affidavit only, my lord. Yes, page 21, my lord. This is a draft rule which was placed before your lords.
Right.
Page 21.
CDPO.
Yes, CDPO, my lord, a child development project officer, and 1 by direct recruitment on the result of examination, and 2 by promotion amongst these graduate supervisor with 20 years of above experience on the basis of seniority.
Under consideration for approval.
75 to 25. That is the only thing under consideration, my lord. Now, as on today, because of
this court is asking whether 25% will constitute 5 posts.
5 posts.
Now, they say 5 posts, my lord. There is nothing on record. On what?
You should know how many posts.
No, because they should write, because it's their case, they should establish, or why I should establish their case, my lord. That is what and they say that you come. My statutory, I am really surprised, my lord, what they are saying is that these are the statutory rules. I am trying to fill those posts which are vacant, my lord, to provide services to them, and they are saying that no, I have a right, their right will fructify when rules are amended under Article 309. As on today, they have no legal right. On assurance, they are saying since there is assurance, and therefore all these posts, and they should make one averment that all these posts are relating to 25%. My lord, I have gone through, I've read whole thing here in the court. I didn't see any single line that these posts are related to promotional posts or my quota, and what is the total cadre strength also.
No, the quota is still a consideration. That is why.
So they even assuming
expectation in view of the draft rules that have been made.
That's why. So, my lord, I have not come across a single. With respect, my lord. With respect, my lord. They are trying to set up.
Washed away. If that's maintained,
it is basically going to create a chaos.
My lord, I don't know this chaos argument. Chaos argument is only argument which is there in law is, my lord, that if the statutory rules are there in the place. In the statutory rules, we are trying to enforce.
Understood.
Yes.
The statutory rules
But
would
the
be
only
there,
thing
my
is
lords, if
that
we are
now-
not amending
If
it.
they have, if they have right,
by
Milo.
own draft rules,
My,
you
Milo,
have
suppose
contemplated the
now draft rules will come prospectively or retrospectively, my lord. If I notified the draft rule today, the posts which are there on today, that will come into under the rules, my lord. Prospectively, rules cannot be applied retrospectively. What my friend is
We
saying.
don't know how many posts will be kept vacant.
So therefore, that is the issue. Because there has to be some.
Let there be a via media, if your lordships permit me. What we could probably, my lords, it's just a suggestion, my lords, for your lordship's kind consideration, that even if the selection process is to proceed, my lords, that they should not be culminated before your lordships are finalized, before your lordships finally decide this matter.
Yeah, that'll be fine.
It balances the equities for both sides.
Yes, sir. Miscase number 219 is in the PC number 205/2024. This application has been filed by the petitioners for stay of the advertisement dated 27/11/2024, whereby applications have been invited for the filling up of 9 posts of child development of project officer under the social welfare department. Stop. Mr. K. Paul, under senior counsel, on behalf of the applicant stroke writ petitioners, has submitted that though a categorical statement has been made in the affidavit of state respondents filed in the main writ petition that the matter concerning the promotion of the legible what the post legible petitioners is under active consideration. If the posts are filled up as per advertisement, there will be no question of the repressions being promoted. As
Yes.
such, he praised that in the interim, the advertisement be not given effect to stop. Next paragraph. In reply, Learned Advocate General submitted that
There is
at present the service is at present the filling up of vacancies is governed by the prevailing statutory rules, which has provided that to the post that for filling up of the post of child development officer is strictly by direct recruitment, and in the view of the matter, the advertisement has been issued. With regard to the other submission, that the state respondents are in contemplation of affording promotional avenues to the petitioners, the applicant submits that the same is still in the gestation stage and yet to fructify, and as such, the petitioner cannot derive any vested right as yet. Stop. Considering submissions of the council parties on perusal of the advertisement, which indicates that the last date for submission applications is on 27 December 2024. Minister of Justice, though the section process can carry on, the same shall be concluded until the matter is taken up on the next date.
Yes.
Yes, accordingly, this matter and so and so. Find out how many, because we have to know the
We'll give the exact cadre strength, my lords.
Right.
Supplementary 1, item number 1.
What is this?
Please, Lordship.
This is Accounting General Audit and others.
No, my lord.
Then
I'm sorry, Lordship.
Supply one.
Supply one.
Sorry, please.
My copy नहीं supply से रहा. My copy. My copy. I should copy. ठीक है नहीं Okay. Renu Devi.
Yes, my lord.
Yes.
My lord, here, the petitioner herein, my lord, sees the legal error of late Dhaka Kumari Upadhyay, my lord. These respondents number 2 to 5, my lord, they are the legal errors. My lord, here what had happened.
You also legal error?
Yes, my lord.
Then
I'm the sister, my lord.
5,
2, 3, 4, 5, my lord, they are brothers. I'm the sister, my lord.
You're a sister?
Yes, my lord. Here what had happened. My lord?
You all co-heirs?
Yes, my lord. Co-heirs. Here, my lord, what had happened. Sensing foul play on the part of the respondent number 2 to 3, my lord, the petitioner herein had issued legal notices, my lord. Subsequently, my lord, partition suit was filed. And my lord, wherein the respondent number 1 herein was also added as pro forma defendant number 6, my lord, before the trial court, my lord. Notice was served upon, my lord. They failed to appear, and the matter proceeded ex parte against the respondent number 1 herein, my lord. Thereafter, my lord, what happened? The petitioner herein had also written a letter to the respondent number 1 to refrain themselves from partitioning, from, my lord, mutating or doing any such kind of act that shall prejudice to the petitioner herein, my lord. So times and again, my lord, the petitioner went to the office of the respondent number 1, gave letters. In spite of that, my lord, this patta has been mutated, my lord.
Where's the patta?
My lord, I have issued the order. I have enclosed the order, my lord. If my lord may kindly come to page 70, my lord.
Pendency of the suit?
Yes, my lord, pendency of the suit. And interestingly, my lord, what they say.
Orders operating?
Yes, my lord.
Are the injunction orders?
No, my lord. No, my lord. But here, what they are saying, my lord, they are not aware of the pending proceedings, my lord.
Yes.
And pursuant, my lord, to this order, if I may take your, my lord, to the typed copy of the order, which is at page 73, my lord. If I may read, my lord.
Yes.
The Darbar of CM Hima Milliam has received a request application from Arjun Upadhyay and Govind Upadhyay to distribute patta number so and so, which is in the name of Dhaka Kumari Upadhyay. She is the mother of the petitioner herein. The Darbar of CM of Hima Milliam, according to so and so, had summoned the matter to this Darbar of the CM on so and so, and on behalf of the CM on the Hima, we have been pleased to survey this area. The Darbar of CM of Hima Milliam, Hima, in compliance to so and so, the survey was conducted on so and so for the place of Dhaka Kumari Upadhyay in the presence of Rangbastong of Upper Rumparing. The Darbar of CM of Milliam has received a letter from Renu Devi dated 20th June 2022, not disputing, my lord, requesting for a share, and in this regard, we have requested clarification 2 times from Darbashnong Rumparing regarding the request for a share. The Darbashnong has not responded to the request of Renu Devi. Therefore, we have rejected Renu Devi's application, my lord. Then, the Darbar of CM, in accordance with the Purvana so and so, has decided to allocate the land so and so in presence of Rangbashnong of Upper Lumparing and the parties. Therefore, in order to reconcile the 2 parties, it was decided to divide into 2 parts. One part for Arjun Upadhyay and Govind Upadhyay, which has an area of so and so square meter, feet or more or less, and the other part for Lochan Upadhyay and Veem Upadhyay, which has an area about 370.0793 square meters, 3983.5 square feet, more or less, according to the survey map. On next paragraph, during the inspection, Lochan and Veem Upadhyay said the matter is in court. But when Darbar asked for a notice from the court, they said that there was no notice, my lord. In fact, these persons who have been referred here, they are also supporting the case of the petitioner, my lord. They are brothers. They are also not disputing that I am also entitled for a share in the property, my lord.
No, but doing inspection says no notice meaning.
My lord.
It's not supporting your case.
My lord, my lord, before the trial court.
Son and him were
Yes, my
supporting
lord, before the trial court, my lord, in the written statement, they have categorically stated that I am
not supporting you.
My lord, yes, my lord.
But out here they're not supporting you.
My lord, they are supporting, but this is order passed in absence, my lord. Here, what has happened? Subsequently, my lord, what happened? After getting this patta, they have started, my lord, construction this suit premises, my lord.
Where's the proof of that? Have you annexed any pictures?
Photograph just recently, my lord. Just I have received yesterday, my lord. I have received the photograph, but there is no dispute, my lord.
No, but then why don't you go to trial court for orders?
My lord, here, my lord, the vacation, my lord, vacation is. And my lord,
civil courts open till when?
Till 20th, my lord. But what happens is, my lord, to dispose of it might take some time. I'm just praying for little protection, my lord.
Yes, Mr. Karim.
It is till such time, my lord.
Like your lordship has suggested, they can approach the
why coming here? Because
they themselves have filed the civil
matter. Create another.
Just, my lord, limited protection only, my lord. Just 10-15 days time, my lord, so that at least they'll refrain from my lord, carrying out any legal construction on these terms of this patta, my lord.
Shows the factum of construction, Mr. Panthi.
We have received the copy, my lord, on 16th, my lord.
Yesterday we served the copy, my lord. We served the copy.
They are well aware of the fact that the order, my lord, was passed way back in 21st August 2024.
But they've started acting on the order.
August,
yes, my lord.
You didn't go to once you file a interrogatory application before a trial court.
My lord, here,
of this order.
Here, my lord, what has happened on the strength of this order, my lord. Just recently, what happened, my lord, they have started carrying out the construction work, my lord.
No.
That is our grievance, my lord.
When this patta was, when you received copy of this, when we were made aware about.
They have not given us the copy, my lord.
Where do you get this from then?
She's not staying. She's in Delhi, my lord. She's not aware about all this, my lord.
No, where do you get this? This order 21/8, correct? This order of this email. Yes, when did it come to your possession?
My lord.
When did you come into possession of this order, or when did you get a copy of this order? 21st August.
We have come to knowledge about this order, my lord, from the other respondent, the 3 and 4, my lord. Just recently, my lord. Just last week, my lord.
Then you should have gone to the trial court. How do you expect? There's no fact.
Only, my lord, kindly, my lord, I am giving undertaking with the bar, my lord. I placed the photographs, my lord, today itself. I have there said it, my lord. And my lord, in the event, my lord does not intervene.
She's still in Delhi now, also.
She's in Delhi, my lord.
Not even if the
just limited, just 10 to 15 days, my lord, just 2 weeks. I'm not praying for longer.
This will happen 10-15 days.
At least, my lord, they'll refrain from.
Civil courts are going to close also.
But they'll refrain from my lord, carry out illegal classes. Immediately thereafter, my lord will approach.
Where is the statement?
My lord, if your lordship kindly see the even the signatures of the in the writ petition, my lord, if your lordship kindly come to page 35, which is the stamp paper, e-stamping, my lord will see the signature down below, and the signature which has been signed in the writ petition, my lord.
He's literate.
Yes, my lord.
He's illiterate.
She's literate. Little bit, my lord. Not that.
Whether it's genuine petition or not, my lord.
Who has where's the wakalat?
My lord, will kindly, if your lordship kindly see page 35, signature is down below in the e-stamping, my lord. And your lordship will see this the signature which has been appended in the writ petition, my lord. Totally different, my lord.
She's aged, my lord. She's aged, so expected that
can be so much of a difference.
Signature varies.
E-stamping is of 11th August 22.
Yeah, that's the signature. Yes. See, the executor in the wakalat seems very firm, and the
she's 41 years old only, my lord.
41 years old.
It varies, my lord. See.
She's very advanced age, 41 years old.
Not advanced, but I'm saying it's.
What will make us say that we are ready for.
Serious doubt, my lord, as far as the petition is concerned, my lord, whether the petition has signed on it or not, my lord. Vast difference between the signature which has been done in the writ petition as well as in the e-stamping itself, my lord. They can approach the civil court,
regarding my lord, that construction work I have mentioned the evidence.
2 more days are there. They can approach the civil court.
You should have filed it there. Why?
My lord, kindly come to page 11, my lord. Page 11, my lord, para 11.
Who reported to her that this construction is going on? There must be some person here who's looking after interests.
Not only that, my lord, there are the parties in the suit. There are 4 parties in the suit, my lord. The plaintiff, 3 parties. It's not only the present
See,
petitioner, my
seeking
lord.
injunction, Mr. Panthi.
Yes, my lord. My lord, kindly come to para 11, my lord. Page 11, para 11, my
Yeah.
lord. If I may read, my lord. The petitioner
Oh,
states
there,
that
where? Show me some. See, this is a court of record.
carrying
This,
out
we
illegal
just got
constructions
materials.
interfering with the electricity, my lord. My
Once
lord,
you bring disputed facts, Mr. Panthi, and especially the matters pending,
I
we'll
can
do
place
one
it.
thing. Yes,
I can place the photographs, my lord. My lord, I have it with me. My lord, I may crave leave also in court. There is
yes,
some urgency there.
the writ petitioner, maybe instant petition, has come before this court with a prayer. With a prayer to not give effect to the impugned
Pata, my lord.
partition.
It's a partition
Impugned
order.
partition order.
Yes, my lord.
Dated 21/8/2024, which has been given in favor of the respondents number 2 to 5
Yes, my lord.
by the respondent number 1. Stop. The writ petitioner is submitted, and the respondents 2 to 5 are brothers and sisters who are who are entitled to shares in the property of the deceased mother, one late L. Dhaka DHAKA Kumari Upadhyay. Stop. It is submitted that without her knowledge, without writ petitioner's knowledge, the other respondents have obtained the partition order for the property of the late mother, and she has been deprived of a share thereof. Stop. Where's the suit? When he instituted?
My lord, it was filed on. My lord, can you come to page
2022, my lord.
Page 17, my lord.
In spite of a title suit which is pending on the same subject matter in issue, being title suit number 23 bracket T of 2022, pending the court of the Assistant Deputy Commissioner at Shillong. Stop. Submissions have also been made that on the basis of the impugned order dated 21/8/2024, the said respondents, that is 225, are commencing construction activities on
My lord, number 3.
Huh?
Number 3, my lord.
Number 3 only.
Yes.
That's number 3 is commencing construction activities upon the suit land, for which the petition has no alternative but to file instant application before this court. Stop. From the side respondent number 1, which is represented today by Mr. L. Kareem, it is submitted that firstly the impugned order has been passed as way back as on 21/8/2024, and the petitioner being well aware of the same, especially aware of the same, should have approached the trial court for appropriate orders, considering that the suit involves the question of partition itself. He submits that the further no materials have been brought to record before this court to show that to evidence the or to support the contention that construction activities are going on. He therefore submits that alternate remedy being available, the writ petition be not entertained. Stop. Have heard the counsel of the parties also examined the materials under record, materials as placed by the counsel for the petitioner. The writ petitioner has annexed Annex 3 to the writ petition the copy of the plaint of title suit number 23T of 2022, which is a suit for partition and declaration of right and interest. At what stage is the suit now?
My lord, issues and documents, my lord.
And as submitted, it is a stage of issues and documents. Stop. It is also noted that the respondent number 1 in the incident petition is also arrayed as performer respondent number 6 in the said title suit. Stop. This being the situation, and coupled with the fact that no materials have been brought on record to show that the suit land is being not been able to show that there's construction of suit land at this stage, and also due to the ability of alternate relief, this petition is not entertained at present, and the petitioner has at liberty to approach the civil court where the suit is pending. Stop. Concession that will be made favor. A concession is given, however, that on such an application being preferred before the trial court, the same shall be taken up and orders passed thereon immediately.
Well, Annex 5.
That's it. And matters with these alterations, matter stands. Yes, that disposed of. Yes. Yes.
Annex 5. May kindly come to last part, my lord. It is therefore implied the defendant has no intention to contest the intent suit, and hence instant case shall proceed ex parte.
Better still.
Ex parte against my lord respondent number 1. Ex parte against respondent. My lord,
6 also.
6 is my lord, same of million, my lord. Same million, my lord. So they are saying they are not aware of pending proceedings.
If you agree with that partition order, more so not to get orders for that, that will take
my lord, may kindly just allow me leave to photograph.
Get order of the trial court, no? Yes. See, we cannot multiply the litigation.
But my lord, looking at the conditions, we're making humble prayer, my lord.
Grasp any drowning man grasps any straw.
But openly they are saying they are not aware of the proceedings, my lord. The order is there to that effect. My lord.
Yes, Your Lordship. Well, this is a writ petition by the university, Your Lordships. Now, my Lord, Lordship is aware about those EPF contributions. So, for the university is concerned, my Lord, till the year 2008, we are not aware that we come within the sweep of the act.
Why you got a 7Q14B notice?
My Lord, I'm just coming to it. Now, what happened, Your Lordship? We have never received, respondent never pursued. 2007 and 8, some official visited. And they, my lord, had a meeting, series of meeting with the university, and what they intimated that you come within the sweep of this act. And there were formal communication thereafter. Then they have notified also what are the contribution from the NEHU in respect of the work charge and other employees. Now, my lord, they also advise you will have to, because my lord, to make the payment, a EPF code has to be allotted. Now, EPF code was ultimately allotted in the year 2009 by the respondents. Thereafter, what happened, my lord, from 1st January 2010, my lord, we started remitting the contribution from 2008. From 2008, we started paying, my lord. Now, what happened, respondent, my lord, picked up a new issue. They said, what about the backlogs? Because the fund was created from 82, March 82. So, from March 82, you were supposed to pay. Now, we had some serious problems. Some records were not available. Anyway, my lord, what they did, they had drawn up a proceeding under 7A. For determination. For the period, this is very important, my lord.
Yes.
For the period, my lord, March 82 till December 2009. Though I have been paying from 2008. So anyway, my lord, that proceeding was pending and going on, your lordship. So in the meantime, what happened, my lord? We were paying in 2012, February 2012. They switched over to online mode. Payment switched over to online mode. For which, my lord, a login code has to be activated. Now, login code has to be activated by the respondents. Otherwise, I cannot pay. Now, what happened in February, my lord, when I tender my payment manually, not accepted. Then I tried online, my lord, not activated. I intimated them, this is the situation, please. Now, their contention is, unless we resolve, your backlogs are resolved, all the names are uploaded, you cannot. Then I made a request, my lord, I'll take my lord to those letters. Formal request repeatedly made, make an alternative arrangement, at least this period, starting from February, my lord, when it switched over to online, make an online alternative arrangement, give me a temporary code, accept the money, or I'm ready to give it manually. We tendered it by check also. They did not accept. They formally, my lord, wrote a letter to us. We cannot do that. Acceded to your request. Then ultimately, what happened, my lord? That 7A, which was pending, ultimately, my lord, ultimately it was decided in the year, my lord, 2019, December 2019, and October they activated. The moment they activated in October 2019, we started making all the payments and uploading of whatever available to us, and this process was, entire process was completed by 2021.
Yeah.
So all the contributions were paid, no problem.
But the backlog also.
By everything has been done, my lord. Now, my lord, I am concerned with this period, your lordship will take note. February 2012, when they switched over to online mode, they refused to take, my lord, manual payments, and they did not activate. Till, my lord, 5th May 2019, this was the period contentious. Now, my lord, I have cleared everything. Now I received in 22, I received a notice for damage and interest for belated payments. For belated payment for this particular period. Now, my lord.
Where is that notice?
That notice I'll take, my lord. That notice is page 54. Page 54. Your lordship. This is dated 7/2/2022. Lordship will see the period, my lord, on the top, 1/4/2010 to 31/1/2022. But actual period was not this. Actual period of assessment they made in the annexure they have enclosed. If your lordship come to page 56.
Yes.
Page 56 is the effective year of assessment. Lordship will see on the top, 2/12, that is February 2012. Till my lord I'll take my lord to page 61. Page, my lord, sorry, page 62. Page 62 in the bottom, 5/2019.
Yes.
So the effective period was, my lord, February 2012 till May 2019. The period for which activation was not done. I'll take my lord to this records. I tendered manually, that was not accepted. Now they charge me for.
No, see, what they're showing here is like for 212, due date was on 15/3/2012 and payment was on 26/8/21.
Lordship.
Now 3/12, same thing, 21. All 2012 dues you paid in 21, 21,
Lordship.
21.
Lordship.
And the last one, you said 5/19 was paid in 20.
20. That's what I'm saying, my lord.
Yes.
October they have activated.
October of 19.
2019. Thereafter, we started the process, and we are not denied.
Prior to that, from this 12, they didn't accept your check
No,
payment.
no, that is the whole issue, my lord. That writing, my lord, just saying I know is not enough, my lord. I'll take my lord to this. So this period, my lord, we started. There was a COVID. All right, my lord, COVID situation disruption is there. So 2019
online payment.
Online payment we started. 21 we completed the exercise. You know, these were very correctly reflected.
And what's the interest and damage they're claiming now?
Altogether, it was counted over 9 crores.
Now,
more than the contributions. Now, my lord, I'll take my lord to those relevant where they have refused. These are very important, your lordships. If I can take my lord to page 37, our formal request.
Yes.
Page 37.
Letter date 12.
My lord, 38 is the, my lord, type copy. That is, my lord, 26/9/2012. Even just, this is addressed to them. Post subject, the letter referred to above discussed held your good office on 31/8. Before that, my lord, personally also we made a request. We have been kind enough to hear our problems not being able to trace out the old records, daily wages of worker engaged by the university since 1982. Though we could furnish the data from January 2008 onwards, which led to the difficulty of activating the NEHU PF account number suggested, whereby EPF contribution check issued from April 2000 could not be uploaded for want of online registration to be activated. As per the subsequent hearing had in your office earlier, the other pro rata casual laborers available from 92 to 93 onwards are in the pipeline to be considered for EPF contribution, even except for the temporary status casual laborers who were contributing GPF as per government. However, to mitigate the need of immediate activation of the code number so as to enable the EPF contribution in time and to avoid unnecessary revalidation of check issued from April-May 2012, I am to request you to kindly make an alternative arrangement, perhaps by allotting temporary EPF code number NEHU to present. So we have been requesting your lordships, even by check, we revalidated check, 10 of them they have refused. Ultimately, the moment they activated, within 21 we have finished. Now for my lord,
when is it activated?
October 2019. October 2019, we started activating. There were disruption. We don't mind. During this period, if there is a delay after activation, my lord will not say anything. It is for them. Now, my lord, for entire this period, my lord, there are subsequent communication also. Now, what is their reply, your lordship? Their reply is next page, my lord. Type copy is at page 40. Subject activation of NEHU code. With reference to your letter number such and such, dated such and such, it is to intimate you that allotment of temporary cannot be acceded to unless PF account of all members allotted serially as on date joining the fund. Further, ECR establishment is advised to complete this database of all employees so that ECR online payment can be made. As such, you are requested to appear before this court on such and such. Now, similar communications where I have annexed 2014 also, they have refused all throughout your, my lord. Now, my lord, as regarding, my lord, 82 and all, my lord, backlog, those were the issue in the pending proceeding under 7A. Now, there, my lord, we have made a statement, my lord, made an admission before the part of the records were lost. Ultimately, in 2019 December, my lord, when they decided it, they asked us, you file an affidavit.
Where's the last impugn order? They've tried to attach your accounts.
My lord.
No, we have not.
Then are you making
15
any
days. This order was served on us 2nd December, and they said within 15 days. So, my lord, my humble submission at this stage, let it come up immediately after vacation. But give us proceedings, protection.
Big instructions.
Lordship, just some simple submissions, Lordship. It is an appealable order, Lordship.
This I have done, sir.
Lordship, this is an appealable order and under 7I.
Oh, yes.
So, since there is the appeal lies, I'm not disputing that they don't have a case. I'm not disputing that. But the provision is that when an appeal lies before any court, the High Court, to my understandings, under 226, the High Court cannot interfere directly. Lordship, as an appeal,
They can interfere indirectly.
as an Lordship, as an appeal from the appellate tribunal, when appeal comes, the High Court can interfere. But when a appellate tribunal is already there, so in some of my cases, also Lordship,
You showed the counsel the other judgment of this court.
Lordship, yes, Lordship. In some of the judgments, Lordship has passed some of the judgments wherein Lordship has stated to file an appeal. Lordship had stated the matter that giving a protection to approach the appellate tribunal. But here their prayer is not that also, Lordship. They have come as a writ, not as a protection before going to the appellate tribunal. Now, Lordship, in some of the Supreme Court judgments also, Lordship, in
Yes.
In this case, Lordship, para 11, Lordship. Our court, para 11, Lordship.
Yes.
First, we deal
Let's
with.
just see the order. The order, Mr. Sun, shown
Yes,
order. Where's the
Lordship.
order? 2711.
Lordship, the order is at page
My lord,
number
here I'll just clarify, my lord.
78.
That decision I'll rely on maintainability. 7Q, 14B. 14B is appealable, 7Q is not appealable. This issue has come up already before Supreme Court. Now what happened? Now Supreme Court says 7Q is not appealable. And appeal is a creature of the statute. If it is not provided, appeal will not lie. But if it is a composite order along with 14B, then it is an appeal will lie. And here, my lord, what happened? Common proceeding, two distinct separate orders were passed. One independently on 7Q, one independently of 14B. That's how I am before my lord.
Lordship, that I'll come in my judgment also. First, to satisfy Lordship.
Anyway, yes.
Lordship, let her file the affidavit, my lord. Let it come up immediately after vacation. And Lordship will decide that, including maintainability.
You should notice MSP Varsaji is present and accepts on behalf of all the respondents. No further notice called for the grievance of the writ petitioner, which is the responsibilities with the impugned order dated 27/11/2024, passed on section 7Q of the Employment Provident Fund.
14B and 14B and 7Q.
Yes, no, this is yes. First under 14B is 27/11/24. Both orders from me. Agree with the orders dated 27/11. 2024 pass under section 7Q and 14B, whereby the respondent university has been held liable to pay the EPF amounts under section 7Q on account of belated remittances and number 14B and 7Q order to belated remittances stuff. Next paragraph is submitted by Ms. S. and Leonard Counsel with petitioner that the delayed remittances are not attributable to the university, but it's in view of the
activation of login code.
Our login code, which therefore has resulted in delayed payment stuff. He therefore submits that as the notices have mandated 15-day period for compliance, that some interim protection be given as a stage. Next paragraph, MSP Varasaji at the outset has raised questions on the maintainability of the writ petition and submits that there is adequate alternative remedy available to the petitioner under the statute itself to seek redressal. Next, she therefore prays that the writ petition be dismissed at the stage itself and directions to issue to the writ petitioner to avail of alternate remedy. Yes, next paragraph. I've heard the counsel of the parties heard the counsel of parties and also peruse the writ petition, especially the weather sheet summation. That sheet we show on direct payments. Yes, and also the statement showing amounts payable under 7Q and 14B, and the upfront will stop. If the submission of the counsel for the petitioner is correct, the said dues for which delayed payments have been made was for the period when the code was not activated. Stop. Accordingly, in the interest of justice, till the next date is indicated, no course of action be taken against the respondent. Stop.
Then this will be my notice. That order will be stayed.
No course of action will be taken. No course of action will be taken. And
this order remains still, Your Lordship. 2711.
yes, and consequently, the orders 2711 shall not be given effective until the next date.
Yes.
So MSP right to file affidavits by next date.
Lordship. Obligement.
This is a matter of admission hearing also. You see, anyway.
Item number 3.
Yes.
Lordship, then I have to file for one more petition.
Yes.
I have to file one petition because we have a strict instruction, Lordship.
Yes, of course, you have liberty to file. Nothing. That's
Yes, because we are under strict instruction that 7I is an appealable order, Lordship.
You file that, and we'll dismiss this petition.
Please, Your Lordship. Lordship, in this application, we're just seeking for extension of time for compliance of the judgment on order dated 16/9/2024, passed by this honorable court, Your Lordship. What has happened
What
here?
time? Which order was your time given?
3 months' time was given, Your Lordship.
Which order? Dated?
16/9/2024, Your Lordship.
16/9/2024.
2024.
So that expires.
See what has happened here. Yes, Lordship. We received this letter, this order. The applicant received on 23/9/2024, sent by the council, Your Lordship. So additional time of 3 months if given to me.
My lord,
We examining the matter, Your Lordship.
To extend 1 month or 45 days, 3 months again it will be.
No, it's last and final time. Let the PS come.
Yes.
I'm short of prize secretaries also, that's why. Hold on.
So this.
But Renal, let him take down. Just take down Miss Case 230/2024. This is an application praying for additional time for a compliance of judgment and order dated 16/9/2024, passed in WPC
230 of 2022.
0/2022. So, seeing the reasons set out in the application for extension of time, and though objections have been raised by Mr. S. Pandit to the time sought for compliance, the prayer of the applicants allowed as a final opportunity to allowed of 3 month additional time as a final opportunity to comply with the judgment.
Highly obliged, Your Lordship.
This case stands disposed of.
Hearing. Item 16.
Please, Your Lordship. Your Lordship, I'm praying for some more time for the production of the records, Your Lordship.
Records are with you?
Not yet, Your Lordship.
As per the last order, Lordship, the GTDC were supposed to bring the records out.
Yes, Your Lordship, that's what I'm
28
asking.
August 2024, they have asked for the record. They
28
said that-
August, asked for the records, still
Yes,
not there.
that is the order.
No, Your Lordship.
They said that
We are-
they bring on the next date.
28 August?
Yeah.
Yes, 28 August 2024. There is an
Just
order, my
praying
lord.
for more time, Your Lordship, to get the records.
They have undertaken to produce the record.
We will produce it.
Yes. It is seen from the order sheets that today your name is Lahi.
Langi, Your Lordship.
Langi, sorry. MS L. Langi.
Yes, Your Lordship.
On behalf of the respondents 1, 2, 3, prays that further time be allowed to produce the records. Stop. It is seen that this court has, as far back as on 28/8/2024, 4, directed for production of the records. Stop. Last policy is given to the respondent to 3 for production of records on the next date. List also is.
Most praise,
Your
Lordship.
Lordship, with the court's permission, I beg to mention item number 19.
Don't mention now, when it's called out.
18.
Option open, please. Yes, start.
This is a matter pertaining to plea bargaining, my lord.
Yes. I think we'll take it because I don't have my private secretaries that we exhausted.
Well,
those you give another day. She's old? How old?
She's 69, Your Lordship.
Just out of vacation. The other parties.
spend winter outside at least. She can spend winter outside.
19.
Oblige, Your Lordship.
Yes. Where's El Langi?
Please, Lordship.
Yes,
As per the order, 19 days, nothing left. 19/11/2012. Just this order was only to present the SD. On the last occasion, he has present the order. It is clearly mentioned, Lordship. That, Mr. SD, Learned Counsel, however, on behalf of the respondent, only that waiting that once he appeared, then that case will be disposed. The order 19/11/2024. Nothing is left, my lord. On that, in view of that, this can be disposed of as unnecessary pending, my lord. Very recent. I have supplied a copy also on the last occasion.
Now, President, where's Mr. Day?
He is unavailable at the moment, Your Lordship.
He's on the way to?
Unavailable at the moment, Your Lordship.
That we can see, that's why you're here.
Yes.
Because only because he was not present on that day. And last occasion, after this one, he present, Lordship. And he has supplied a copy of that or this order also, the 29, that 03/10/2024, that copy also we have submitted. It is on record. There is nothing left, my lord.
That?
That order, that's, this is the record from that. On the basis of this order only, the record only, this order was passed. And then, yes. Because their saying is that this money has not been paid to her. They have admitted in that affidavit also. Page 4 of their affidavit, para 7 they have admitted. Only gratuity is remaining. So this is the gratuity amount. And this copy we have supplied also to the JCDC respondent.
Lordship, let it come after
because
avocation.
even if he come also, same order will carry it. This is only to harass the petitioner. Nothing is left. Even I think it will not have any adverse effect on the part of the respondent. It is on record. This is only to delay the matter. Because the order 1911 is very clear. He has appeared also on the last occasion. He appeared on the 6/12/2024. On that day only he is supposed to be, but unfortunately I was in the other court.
To give what?
This petitioner is supposed to dispose of as per the order dated 19/11/2024, because he says that Mr. Day, on behalf of the respondent, pray that matter may be disposed of its presence of the standing counsel. He has appeared on 6/12/2024 after that. But on that day I was luckily I was in the other court. That's why. There's order also on 6.
Yes.
It was adjourned last occasion, Your Lordship. I think it's from the petitioner side.
And this copy of this copy also, that record also we have produced, my lord.
Yes, Mr. SD, then Counsel SC, standing counsel for GC that present in court. Stop. For which MS El Langi has sought some accommodation. Stop. Next one, the same objected to by Mr. P.T. Sangma, that counsel for the petitioner, who submits that nothing remains for consideration in the instant writ, in the instant petition, inasmuch as the respondents by order dated
19/11/2024.
Dated 19/11/2024 have sanctioned the amount of gratuity payable to the petitioner. Stop. He therefore submits that the matter we dispose of that thing the respondents to.
Yes. Only because he has to present. The study counsel is supposed to appear. On that.
No, to pay.
Yes,
to release
gratuity.
the amount.
Yes, the amount
to the
petitioner.
Stop. Though the matter will not be closed today and kept pending, the pendency of the writ petition will not stand the way of the respondents releasing the amount gratuity or the petitioner most expeditiously. Okay.
Some frame time maybe just because
20.
I have been from 2019.
Just after vacations.
20.
For the orders, yes.
Lordship. Much from Lordship.
Yes.
May it please your Lordship. Your Lordship, I believe this matter can be taken up after vacation, as the conducting counsel, Mr. M.L. Napier, have some personal difficulties.
No objection, your Lordship.
Very fast. Yes. Because the parties, that's the matter of vacation.
Much obliged.
Them.
Yeah.